Wait, please. With due consent from the respondent, I beg to mention item number 14, my lord.
14.
14, my lord. Our affidavit in reply is ready to be filed today, my lord. Matter may be taken on next week, my lord.
You are for the petitioner.
Yes, my lord.
After a week.
Obligation.
May I please, Your Lordship? With the consent of the other side, I beg to mention item number 12 on behalf of the counsel for the respondent. He's out of station. The matter may be kindly taken up on 27th May.
Urgent.
Only Lordship, date may be fixed. Okay.
Yes. Yes, date will be fixed.
Right.
May please, Your Lordship. Lordship, with the consent of other side, I beg to mention item number 27, Lordship. In this case, I pray for 1 week time, Lordship. I take further instruction, Lordship, regarding the present status of the case, Lordship. Matter relates to promotion, Lordship.
Urgent.
Obligation.
You ask the court master. They will give it.
My lord, I beg to mention this matter may come up on 24th, my lord.
Which one?
This mentioned for consideration of interim prayer.
Interim bail here.
Interim prayer, my lord.
Here.
Yes. Interim prayer.
Interim prayer.
Yeah. Twenty-fourth.
24th now. 24th. Mr. Gonzalez. You may take another day. 24th will, might be difficult for us.
Let it be 26th.
27th.
My lord, may I pray for my lord an unlisted motion, my lord. Urgency is there. Matter relates to vacation of today. The authorities have served a notice to vacate my premise, that refreshment room in a railway station, Rongia, my lord. Today itself, my lord.
Today itself.
Yes, pursuant to an order of honorable single judge, my lord. That order has been passed. So
What is that? And when the order was passed?
order was passed on 13th, my lord.
13th now, still you have waited up to 20th. What's the urgency? They have vacated tomorrow.
Obligement.
May please, my lord. I pray for listing of a writ appeal, my lord. Day after tomorrow, there is some urgency in the matter, my lord.
What's the urgency?
My lord, the learned single judge has decided on the inter se seniority, totally ignoring the fact that the writ petitioner was in ad hoc service and that ad hoc period was also counted, my lord. The law is settled, my lord. The Supreme Court has held that ad hoc service for seniority cannot be counted.
Wednesday. So they're going to make promotions.
My appointment has been cancelled. So, my lord, there's some urgency. Wednesday, my lord, so day after tomorrow. I'm deeply obliged, my lord.
Wednesday.
May it please your lordship. My lord, I pray for listing of a matter urgent listing, my lord, on Wednesday, my lord. In
What's
this
the
case, that this is
What's the urgency?
the contract is expiring, and at the behest of the contractor, there is an interim order operating. Contract is expiring this week itself, my lord. After that, so we are unable to float a tender process. The tender process is stayed at the behest of a non-participating person.
Stayed by whom?
Stayed by the honorable single judge, my lord. We have prayed
You are against the interim order.
here against the interim order, my lord. We have even conceded the writ petition, but the interim order is still operative. My lord.
Get the hearing of the petition expedited. Writ petition,
My lord, my lord may pass a final order on Wednesday, my lord. That
final order.
my lord may dispose of the writ petition itself. There is a limited prayer, my lord.
Can we dispose of the writ petition when the
Writ
same is
appeal, my lord,
pending
writ
before the learned single judge?
I apologize. The writ appeal, my lord. That is a limited prayer. I'm on a very small point because on Wednesday it's
Thursday,
my Thursday is closed. That is the difficulty.
Wednesday.
Wednesday. I'm obliged.
I beg to mention item number 58, my lord. I'm paying adjournment, my lord. Item number 58, my lord. 58, my lord.
1558.
Yes, my lord. I have taken consent, my lord.
Adjourn.
Yes, my lord.
May I please your lordship? Lordship, I beg to mention item number 50 for adjournment as my senior Mr. S. Committee is out of station. due to some personal difficulty. Consent from the opposite.
Arjun.
May it please the Lordship. Lordship, with the consent of the other side, I beg to mention item number 55 of the daily list, Lordship. Lordship, Senior Counsel Mr. D. Saike has some difficulty today. I pray for adjournment.
Arjun.
Deeply obliged.
Lordship, I beg to mention item number 2. My senior is out of station.
Arjun.
Lordships,
Yeah,
beg to mention item number 39 and 40.
39 and 40.
Yes, Lordship,
Yeah.
we will file the affidavit during the course of the day. Matter may be taken after a week.
Like to file reply. Who prevented you from filing the reply?
Lordship, we will file affidavit today during the course of the day. Matter may be taken up after a week.
Arjun.
Daily list for orders item 1.
May it please your lordship. Lordship, I am for the respondent bank in this case. I am supposed to file an affidavit,
Yes.
but however, the contemners are from Madhya Pradesh Indore, it is taking some time. So next week, your lordship, the matter
Who
may
is
be
taking
discussed.
time?
The papers, the signed papers, your lordship, the affidavit has to come from Indore, your lordship.
Made a specific statement that you are paying pension as per the revised PPO.
Yes, your lordship.
So where is the problem in that?
Your lordship, the affidavit, the contemners, they are from your lordship, Madhya Pradesh Indore. They have sent the papers in next 2-3 days. I'll be receiving the papers, your lordship. After, let me listen after a week, your lordship. In the meantime, I'll be filing it.
My lord, may I just permitted to say something. My lord, here the issue basically, my lord. My lord, that, my lord, the 20%, 30%, that, my lord, they have paid already, the additional amount. What happened, my lord, in this case, that in the meantime, my lord, the pension was revised and it was increased. And accordingly, my lord, I am entitled to 20% more, 20% on the revised scale. Now, my lord, I am getting the pension so far, the, my lord, recent, is, my lord, in, my lord, time and other things. Now, my lord, from 1/1/2016 to, my lord, November 2018.
Yeah.
My lord, the pension has been, my lord, the area pension has not been paid. That is the issue, my lord. My lord, sir, let them, my lord, clarify.
On the last occasion, what we remember, you argued that you are not getting the pension as per the revised PPO.
My lord, I
This
have
was
been,
your argument. That's why only they said they're giving the pension as per revised.
whatever,
PPO.
my lord, briefed me and I have gone through the additional affidavit. My lord, I didn't appear on the last occasion, but it's still then, my lord. No, no, तुम्ही याच्या पेन्शन टू टाइम पैसा नाही पोहायचे हा त्याच्यात होया तो
Now that question, how this then contempt is made out in that case.
my lord.
If they are paying the amount as per the revised PPO, so far as regarding this salary part is concerned, when the area part is concerned,
Yes, my lord.
that area, that is also for the period 16 to 18.
16 to 18, my lord, as I did, my lord, to November 18. My lord, the AG, my lord, the respondent number 3.
What was the direction of the court? What was the direction of the court?
Direction of the court was, my lord, to, my lord,
Where is that? In which court?
that in the benefit.
Where is the order?
I'm just being funny.
Page 29, 30.
Okay, 29, 30.
No. Sorry.
You do.
I'm not correct.
Then
My lord, page 29 of the, my lord, contempt petition. My lord, in the writ petition, the issue was,
Just the
I'm sorry.
What you are claiming that from 2016 to 2018, they have not paid the area.
But the revised pension, Milord, as per the revised pension.
Revised pension, the court has, he would be entitled for the said benefit from 30th of July 2015. This was the order.
That's true, that was the order, Milord.
That was the order.
That
So
was the order.
since 2015 to 16, you got that arrears.
Milord, those has been paid.
Those have been paid.
But in the meantime, Milord, after the judgment was passed, there was a revision of the Milord pension, Milord. And that has been increased. Now, Milord, as per that increased pension, Milord, I'm also entitled 20% on that. Now, Milord,
It's altogether then a new issue. How this order of the
My lord.
court can be said to be not complied with. If they have paid you the arrears from 30th of July 2015 and there later on, if they revised pay was there, then that question.
Milord, at this stage, Milord, maybe, Milord, right, technically, Milord, but the question is that, Milord, this issue can be, Milord, resolved also, Milord, by my lord, because to relegate the, Milord, petitioner to go.
Notice you filed this affidavit also.
In the meantime, Milord, the respondent number 3 also may be directed to, Milord, check it.
Just a minute, sir, please let us ask him.
Respondent number 3.
In between, if the pension was revised or some additional was there, then you have to pay the arrears of that.
Worship, to that effect also I'll obtain the instruction. In the meantime, I'll be filing the affidavit and also will obtain the instruction with regard to
You also filed this affidavit of this applicant. But in concept of the respondent, that he needs some more time to file an affidavit to the effect that the petitioner is getting full pension as per the revised. Over the concept of the petitioner has submitted that. Though he's getting the pension. Though the petitioner is getting full pension as per the revised PPO. But so far as regarding the arrears of the salary running from period
1/1/2016.
2001 to 2016.
1/1.
Pensions.
1st of January, Milord.
Arrears of pension from 1/1/2016
To
to
November 2018.
November 2018 has not been paid.
Pursuant to revision.
Pursuant to the revision of the pension has not been paid to the petitioner. Full stop. Then concept of the respondent there has submitted that a clarification in this regard would also be filed along with the additional affidavit. Less or 2 weeks ke baad.
Milord, the respondent number 3, the Office of the Accountant General also maybe because if they have not.
Respondent number 3,
From the Accountant General, Office of the Accountant.
let them file their response then. Yes.
Obliged.
Item number 6.
My lord, the affidavit has gone for vetting. It just need 2 days time, my lord.
So when you are going to file affidavit?
My lord,
By what time you will file the affidavit?
I can find by day after tomorrow, my lord.
Okay, Mr. D. Gogoi and counsel, please.
Date may
Fix for the time.
Porokhile
To
question.
file counter to the instant interlocutory application just after a week.
All right.
Item number 7.
In this case, notice was already issued, my lord. The respondents have entered appearance. And my lord, I have preferred this appeal. State has preferred this appeal, my lord, against an order passed in a writ petition, as well as against the rejection of my review. So, my lord, the review was rejected primarily on the ground, my lord, it is delayed. Since, my lord, this review was a review under Article 215, read with 226, my lord, the strict principles of limitation. In terms of the limitation act should not have been.
But, strict principles of limitation may not apply.
True.
But ultimately, if the review is delayed, then court can pass an order on that also.
True, my lord will kindly appreciate the cause of action of the petitioner arose in 1999. They instituted writ petition in 2015. That was entertained. My review was delayed by 2 years, 3 months, my lord.
That can't be compare
True,
all
man,
these
true,
things.
true, man. But in the meantime, my lord, 2 years of COVID was there. I filed an affidavit explaining my delay. And my lord, there are judgments to indicate, my lord, that the principles of limitation strictly,
may not be strictly applicable.
that too in a 215 application. It's a review under Article 215, my lord. This honorable court, being a court of record, is maintaining record in correct form, my lord.
When this order was, earlier order was passed,
Earlier order was passed in 2018, my lord. That
2018, and you preferred the review petition in which year?
21, my lord.
21, after 3 years.
2 years, 2 years, 3 months. In the meantime, my lord, from December onward, December 2018, it was. But I have filed an affidavit to indicate the delay also. Just to justify the delay. 06, no? But original judgment is of 10th of December 2018. And I instituted review on 26/3/2021. In the meantime, my lord, there was COVID. We caused some inquiry. Everything was explained, my lord. And in the process, what has happened, my lord, these appointments apparently were made illegally. Those appointments were cancelled within a month of those appointment orders, my lord. That was never placed before your lordships. But only 2 documents, my lord, the error apparent of the face of the record is so glaring. Only 1 document reveals everything. Only 2 documents, my lord, reveals that was
Maybe, forget the review, and do it on merits.
on merit, my lord, will kindly page only 2 documents, my lord. Page 137 and 150. 137 is the type copy. I would like to take your lordship to page 138, my lord.
Just, what's the controversy? Why they?
My lord, they say they were appointed, but they were not paid salary.
They were appointed.
But they were not paid salary against the scheme.
You just, sure, they were appointed in the year
8/10/1999. In 2002, my lord, they instituted the repeat.
Just,
My lord,
let's start from the beginning.
my
Yes.
8/10/1999, my lord. 10/1999.
8/10/1999.
They say they were appointed.
Appointed on which post?
No post, my lord, against the scheme, different scheme. My lord will kindly page 138. That's the
They were
appointment.
appointed as a casual labor. or-
Yes, my lord.
Where is that order?
Page 138, my lord. Page 138. It's very interesting, my lord.
Read.
In pursuance of the Honorable Minister Irrigation Assam White Confidential Letter number so and so, dated 23rd July 1999, the following candidates as selected and approved on the basis of their requisite qualification, experience, merit for the post of different irrigation scheme. As per lease enclosed herewith under this division have been appointed in the scale of pay of so and so, plus all other allowances admissible as per rules with effect from the date of joining. This order is purely temporary, may be terminated at any time without assigning any reason. Next page, my lord, will see serial number 10. This order is copy marked to Podumbora, one of the writ petitioners. I don't know how this order traveled to his home or whatever his address, my lord. Without making any reference, any address, he obtained this. Anyway, my lord, I'm not on there. Podumbora.
Nitin Barua.
Podumbora, my lord, 139 page.
139.
Serial number 10, copy marked to Podumbora without any address. He received this letter, order. He joined, my lord.
This serial number?
10, my lord. Last handwritten, my lord, Sri Podumbora.
Sri Padambora, PPO for information necessary. He might have collected from the office of the.
There was no selection also, my lord. There was no advertisement. There was no select list. Okay, my lord. I'm not on that, my lord. 150, my lord. Page
115.
150.
150.
Immediately on the next month, my lord, it is dated 16th of November 1999. Next month, my lord. The government in the irrigation department issued a letter to the executive engineer. This letter, my lord.
Read.
It says, I am directed to say that 6 numbers of persons have been appointed by Sri A. Rahman, executive engineer, White Office, order number eligible dated 8/10/1999, the earlier order, my lord. Copy and close. Irregularly without observing the requisite formalities and beyond sanction strength, which is viewed seriously by the government. You are therefore hereby directed to cancel all appointment orders immediately with a copy to this department as well as the chief engineer irrigation. This was followed by the order issued by the executive engineer, page 151.
Pursuant to the appointment order,
Where so and so is hereby all appointments were cancelled. They, my lord, without making challenge to these orders, preferred a writ petition in 2002 saying that they should be paid salary. This honorable court passed an order directing to make a consideration of their claim.
where is that order?
That order, my lord, finds it page 153. My lord. Relevant page would be,
These 6%, all these 6%.
yes, my lord. Beyond them, my lord, there are 8 others, my lord, 10 others. These 6 are already in this petition, my lord.
Okay,
Page 159.
Yeah.
Para 3. The
Yes.
case of the 16 petitioners in this writ petition is that they have been selected for grade 3 and grade 4 posts in Tesco Irrigation Department pursuant to their appointment. They have joined on 12/12/10/1999, but they have not been paid their salaries as yet. They have therefore moved this court under Article 226 for constitution for appropriate relief. I dispose of the writ petition with a direction that a certified copy of this order and a copy of the writ petition will be filed by the petitioner before the commissioner and secretary to the government of Assam Irrigation Department will consider the grievances of the petitioner that they have not been paid their salary as and pass orders and communicate the same to the petitioners within a period of 1 month from the date of receipt. So this order alleging non-violation of this order, in 2003 itself, they instituted a contempt petition. That contempt petition in 2009 was withdrawn by them.
where is that?
That my lord finds at page 160. 160 it starts, my lord.
167 is zero.
Relevant page is page 166. The learned counsel, 166, the learned counsel for the petitioner submits that he has instruction not to press the petition. In view of the above, the contempt petition stands closed. Since then, my lord, they kept silent.
So this was dismissed in 2000,
9, my lord.
pending remained 2003 to 2009.
Nine.
Remain pending.
Remain pending, 9 day withdrew.
Why?
19/10/2009. So they never challenged the order of termination. The order of writ petition, though contempt was passed, that was withdrawn. In 2000, my lord, 15,
Yes, sir.
sorry, my lord, in 2000, state preferred, 2009, my lord, another set of writ petition were decided in favor of the petitioners,
Where-
not the same appointee, my lord. That was assailed by the state up to Supreme Court. It was again dismissed on the ground of delay. Another different set of persons, my lord,
different set of persons, not these.
not these persons.
2009.
9/10, ultimately SLP was dismissed, my lord, in
No,
2011.
They preferred writ petition. What
Writ
happened-
petition is of 2009, my lord.
What happened in that petition?
That petition direction was to release salary to those persons. Claiming parity, my lord, in 2015, being silent since 2009, withdrawal of the writ petition. 2015, they instituted the writ petition. The honorable single judge,
Those persons who approached this court in 2009,
they approached in 2002.
2002, they were also appointed in a similar fashion.
No. They were by different appointment orders, they were appointed. Claiming parity, my lord, they filed a writ petition. Honorable single judge, my lord, decided that they should be granted equal relief.
Where is that order?
That is again impugned herein, my lord, at page 303. Thereafter, we caused an inquiry, then these termination orders were found, my lord.
Just
303, my lord. This is the order I have challenged herein also. It's a composite appeal, my lord.
this is 2018 order.
2018 order. Against this, I prefer the review,
Read.
my lord. Second paragraph, the grievance expressed by the petitioner lies on a small campus. The projected case of the petitioner is that they participated in a selection for various posts of grade 4 in the Tezpur Irrigation Division pursuant to an advertisement dated 23/8/1998. After having come out successful in the selection, the petitioners were issued appointment orders dated 8/10/1999. and they had joined their respective duties. The grievance of the petitioner that after joining the respective post, they were neither allowed to work nor paid any salaries. Being faced with such circumstances, the petitioner, along with others, had filed WPC 1342 of 2002. The said writ petition was disposed of by order dated 4/3/2002, directing the Commissioner Secretary Irrigation Department to consider the grievance of the petitioner and pass necessary orders within a period of 1 month. Alleging non-compliance of the aforesaid direction, the petitioners have filed a contempt petition before this court. The said petition had closed on withdrawal. Mr. So-and-so learned counsel submits that the petitioner were verbally assured that their grievances would be redressed, and accordingly, the contempt petition was not pressed. However, the grievance of the petitioner remains unconvinced. Another group of similarly situated persons have filed WPC number 5580/2002. Aforesaid writ petition number so-and-so was allowed by this court by judgment and order dated 4/9/2009. The appeal by the state before the division bench was also dismissed, and thereafter SLP filed in the Supreme Court. The learned counsel submits that in spite of the fact that the issue had attained finality from the higher court, till date the grievance of the petitioners have not been addressed. So-and-so, however, submits that the present petitioners are not parties to those subsequent writ petition, which was decided by this court and had attained finality and dismissal of the SLP, and therefore the relief granted to the petitioners in this case cannot be dealt with in the present petitioner. This court is unable to accept the aforesaid submission. It is settled principle of law that judgment rendered on same issue cannot be denied, but similarly situated persons who had approached the court at later stage. In this connection, reference may be drawn to following decision. These are the decisions referred to. The Honorable Apex Court in the decision of so-and-so was dealing with so-and-so. A similar situation had arisen. The gist of the order is that the petitioner in the said case was entitled to same relief which was granted to similarly situated persons who had earlier approached this court against the order of termination, which were quashed. The Honorable Apex Court had further granted back wages, which was made dependent upon filing an affidavit regarding gainful employment in the period where the petitioner was out of service from the respondent. In the case of so-and-so, the Honorable Apex Court has held that in appropriate cases, the court and tribunals should even condone the delay in granting similar relief to persons who had approached the court or tribunal subsequently. The division bench of this court in the case of Ajant Bora, Supra in para 16, after taking into consideration the aforesaid two decisions of the Honorable Apex Court, has laid down that the benefit of a judgment rendered earlier must be given to other similarly situated persons, even if there is delay in approaching the court or tribunal. In view of such facts and circumstances, this petition is disposed of, directing the authorities to consider the case of the petitioner in the line. The similar considerations were made to the petitioners in so-and-so and pass speaking order on allotting work to them and subsequent payment of salary. Thereafter, this was preceded by an in-house inquiry, my lord, wherein it was found, my lord, those appointments were already cancelled. That was never placed before the Honorable Court. That's why, my lord, we prefer the review.
They were not working. The grievance will be despite the order, we have neither nor paid out. Showing that किसी और का किसी ऑर्डर को उसको फिर बोल रहा है but he did not what is the significance that point
Yes.
We allowed to raise a preliminary objection, my lord, regarding delay, my lord, because there is a delay of 1,500
Delay in
preparing this appeal, my lord,
appeal.
from the date of original order, my lord. The delay is 1,000.
They preferred a review petition and.
Yes, my lord, review was filed, my lord, after a delay of 836 days. So there is already a delay of 836 days earlier prior to the review petition, my lord. And the review was dismissed on the ground of delay, my lord, not on merit. So as far as held by the Honorable Supreme Court, once review is rejected, there cannot be any merger and no appeal is lies against the resolution of an order of review.
There is no quarrel about the.
My lord.
But the.
Even there is no any application for delay.
This time, what is the concept of this appellant has submitted the facts. What do you want to say on these facts?
Yes, I may be allowed to submit, my lord.
Yes.
The facts are on admitted position, my lord, because they did not file any counter in the
They
writ petition.
did not have any.
They did not file any counter in the writ petition. While the writ petition was disposed of, the state did not
What
file.
now? Forget about it.
My lord.
Now, what he is saying that it's, your appointment was made on 8/10/1999
My
and
lord.
immediately after a month, that was cancelled. What do you want to say about it?
Yes, my lord. My lord, it may be cancelled, but we are not.
Maybe cancelled.
My lord, we do not know, my lord. After 22 years, they have brought these records.
You have brought the record, but you just, first of all, you just show.
And our
that
names
you
are
were
not there, my
appointed-
lord.
You were appointed in the year 1999.
My lord.
You approach the court with a prayer that they are not paying their salary or whatever it may be. That writ petition was disposed of
My
in
lord.
the year 2002.
My lord.
Then you filed a contempt petition in 2003, you withdrew that contempt petition.
Lordship.
Then again, you approached this court in the year 2015.
Right.
So you were without any pay, without any work
My lord.
up to 1999 to 2015.
Till date, my lord.
My lord.
And then what about this principle, no work, no pay? Admittedly, you have not worked for a
My
single
lord.
day.
My lord.
Then
I may be allowed to submit, my lord.
you
So far
allow-
as cancellation of my appointment, my lord.
Yeah.
My lord, our names are not there in the cancellation order, my lord. Lordship has already gone through,
so that 8/10/1999
my lord.
order was cancelled.
That was not in our knowledge, it was not
But sir,
served on us,
ultimately, since 1999 to 2015
my lord,
and even till today,
my lord,
you are not working.
my lord.
And you are claiming that payment should be made to them, made to you.
My submission is, my lord, as we are not working because the state is not they are not allowing us to
For
work.
whatever reason. Then
So-
what would be, what would happen to that principle of
That is
no
why,
work,
my
no
lord, we
pay?
approached the honorable court in the year 2002 itself.
No work, no pay, what would be that principle? So then you'll again, you'll claim regularization also, then you'll claim all the pensionary benefits and everything, promotion or whatever it may be.
Well, I may be allowed to rely a judgment of another episode, my lord, regarding cancellation of
We'll hear
appointment.
it. We'll hear it. But
My lord, that is reported,
so far as regarding this delay is concerned, we are going to condone.
my lord, delay is not from our part, my lord, because
Not on their part, yes, but we are going to condone.
but they have not filed even a condolence petition also, my lord, along with the appeal.
Required.
No application for condolence of delay. No explanation,
Mr. Just 1 minute.
my lord,
The principle of law is if a review application is rejected,
my lord,
then the appeal becomes an appeal against the original order. This is number one.
my lord.
Review is gone.
Gone.
Number two, there is no need to file section 5 application in a writ appeal. Writ petition and writ appeal, is there any need to file section 5 application?
Yes,
No,
my lord.
because
The substantive, what my lord is saying, substantive point is your appointments never materialized in 1999.
My lord.
You kept quiet all the years, and now since only because in some other case, the Honorable Supreme Court has passed some order. You have rushed to the court. You are seeking a writ of mandamus. How can you get that mandamus?
My
That
lord.
is the point here.
Yes, my lord. I may be allowed to submit, my lord. We are not sitting quiet, my lord.
Who is stopping you?
So we filed the petition in the year 2002 itself, my lord.
What happened to that petition, sir?
Lordship, there was a direction to consider our case. They did not consider.
Yes, they have not considered your case. You filed a contempt petition.
Yes, my lord.
Ultimately, you withdrew that contempt petition. Even after withdrawal of this contempt petition 2009 up to 2015, you remain silent.
Lordship,
Then suddenly you have filed a petition that this was the, in similar cases, some order is passed.
Lordship, basically, we are economically poor person, Lordship. It is difficult for us to approach this court again and again, my lord. Once an order is passed, and if they did not consider, my lord, that may not be any fault from our part, my lord.
Maybe, sir,
Because there is a direction from this honorable court to comply. They did not comply, my
we'll
lord.
have to hear. Yes.
And as because there is no any application for condonation of delay, my lord. And there is a requirement, there is a limitation of 30 days, my lord.
Having heard the learned concept of the parties and after taking into consideration the fact that The petitioners were appointed temporarily while the order dated 8/10/1999. The respondent, sorry, respondent petitioners were appointed on temporary basis on 8/10/1999. However, the said appointment order was cancelled by the competent authority in November 1999. And the writ petitioners, public respondents have never been assigned any work by the appellants. We deem it appropriate to admit this writ appeal. Hence, admit you are appearing for all the respondents.
Yes.
So so and so put in evidence on behalf of all the private respondents, all the respondents, service is therefore complete. The concept of the respondent may file counter to the writ appeal within a period of 3 weeks. In the meantime, effect and operation of the order dated 10/12/2018 passed in writ petition number 7031/2015 shall remain stay. Clear?
Lord, my lord, may for an early hearing, my lord, because we are at the age of 55, my lord.
That's why only what.
And similarly, citizen persons are
Now-
getting salary, my lord.
You are asking for the salary, then you will ask for increments, then promotion, and then pension also.
That is not our.
Without working for a single day. Without even working for a single day.
Lord, we are not
And
working because of.
in between, God's sake, if anybody is there, then the compensation appointment also. We have been destroyed this situation.
My lord, as because we are not working, as because the resistance from the state, not from our. part.
Ultimately, the fact remains that you are not working for whatever reason. And payment of salary without work.
Deep level.
Item number 8.
Seven, eight, and nine, that is for the appellant.
The state has not been taken, Lordship has directed to take the states. On earlier occasion, his mother was ill. That is why Lordship has adjourned the matter.
Who is the counsel? Mr. You can, S. Chaudhary. Where is Mr. Chaudhary? Please inform him.
Earlier occasion, Lordship has asked me to inquire him. His mother was ill. I have informed according Lordship recorded.
Yeah, that's right. We have recorded. But if he is coming here, today he has come, then. you
Next
ask
week,
him.
Lordship.
Do the need
I will inform next week.
during the course of the day. Pass over for the time being.
Item 9 to 10.
May I please, your lordship? Lord, the notice was issued. We have taken steps and the private respondent has also entered appearance, my lord. And then maybe this to fix a date, my lord. And
Yes.
I am appearing for the appellant in item number 10. We have taken step to dusty service and register for also. An affidavit is also.
You have not taken steps. In fact, this 17/5/1995 August transfer filed an affidavit of the petitioner has been received.
Four and six may awaited.
Affidavit of, what affidavit you have filed?
Complaint of the dusty service.
Yeah,
Dusty service.
so thus the service is completed
Yes,
on 4 and
Yes.
6.
they received.
Where is your affidavit?
affidavit is filed on 22nd April. Maybe
Second April,
Yeah.
almost month. Where is that affidavit?
This is his matter. His appeal. The next one is his appeal. Mr. Bhuya, you are in item 9.
Item 9, my lord.
Item 9, 4 and 6 are unserved yet.
My lord, perhaps, my lord, some private respondent has entered appearance, my lord.
Who has entered for 4 and 6?
Their name has been shown in the cause list, my lord.
And you have not taken steps for Dasti service.
My lord, we have taken the register. Dasti has also been taken, but the, my lord, acknowledged receipt I am awaiting, my lord. For some difficulty, I have a week's time may be given, my lord, I will file the Dasti, my lord.
You have not taken the steps, sir.
No, we have taken the steps, my lord, on 4.
Sir, 4 and 6 has not been received back. Yes, you have taken the neither ready nor answered notice.
My
of
lord.
Respondent number has been received back.
That registered, my lord, is answered, my lord. And we have taken Dasti also, my lord, and that Dasti, I will take a week's time, my lord, and file the Dasti affidavit, my lord.
Nikhil and concept of the appellant has submitted that the notices upon the respondent number 4 and 6
Right.
have been served and is going to file an affidavit of this effect just after 2 weeks.
Obliged.
Along with item 10.
Item 11,
May I please, your lordship?
Yeah.
My lord, here is the case, lordships. There are guidelines for selection of president, vice president. That is notification is dated 27/6/16. And subsequently, that notification partially modified earlier by notification dated is the inspector of
Was
schools
listed for admission, for orders.
lordship, listed for orders.
Yeah,
Service completed, lordship is the office.
respondent number 6 to 8 service is complete.
6 and 8, yes. 6 and 8.
6 and 8. Okay, as per the office report, service of notice upon the respondent number 6 and 8 is complete. Yes,
Lordship, I'm appearing for respond number 7 and 8. Today I'm going to file my vokabulary.
you are appearing on behalf of respondent number
7 and 8, Lordship.
7 and 8.
Yes.
What about the other respondents?
1 to 5 are official. Hmm.
But 6 and 8 is complete as such. Service upon all the respondents is complete. Concept of the respondent number 7 and 8 takes some time to file. Counter to the built up time date for his granted list on terms. When?
Obliged.
Lordship, after 2 weeks.
Yes,
item 13,
Let the respondent number has, I was not filed affidavit. And I further pay 2 weeks time for my rejoinder affidavit.
they have filed the affidavit and you need.
5, respondent number 5 is not filed. And
5 is the first one, my lord. The railway department has supported.
if
My
not
case.
filed, my lord, I will file rejoinder affidavit against the department. Pay 2 weeks time, my lord.
You have already filed or filed?
Not filed, my lord. I pay 2 weeks time.
He has filed. He was filed. And he is also working on the 5 and number 5. 5 is the first. Who has got the benefit. She is the second.
You are for the 5.
Yes, well, I'm the respond. I'm the first wife, my lord. Legally wife.
So what do you want? Would you like to file an affidavit or not?
But since the railway department has supported my case, my lord.
Okay, there is no requirement. Okay. Then concept of the petitioner takes some time to file. Counter to the reply file on behalf of the respondent number 1 to 4, list on sorts.
Item 15.
Please, your lordship.
Respondent number 1 and 1 to 5 are not answered.
Lordship, we have already taken step as per office note 16/5/2024 service awaited lordship.
16/5/2000, we'll await
Service.
await return of notices of the respondents for 3 more weeks.
Item 16 and 17.
Yes, you are appealing for
1 to 4 months.
5 is still awaited. Await return of notice of respondent number 5 for 3 more weeks.
Item 18.
May I please, your lordship. But service report upon respondent number 5 is awaited, my lord. As per office note dated 17/5/24.
Await 4 weeks.
My lord, I will take fresh steps, my lord.
Yeah,
I will take fresh steps, my lord.
fresh.
Fresh, my lord.
Since when it is awaited?
Since last 2 days, my lord.
Last 2 days.
2 days, my lord.
27/3/2024.
March में गया है कुछ.
As per the office report, notice upon the respondent number 5 has been duly served. Over. The notice upon the other respondents have not been served.
I may serve the other responsibility. Issue. Neither.
As per the office report, notices upon the respondent number 5 has not been served. Since long. Stop, learned concept of the
Appellant.
appellant is time to take fresh steps for serving the notice upon the respondent number 5 through registered AD.
Obliged.
984 is granted response.
Item 19.
Lordship, steps have been taken on respondent number 4, I think. Respondent number 4 has appeared. Let it come for admission here.
You are appealing for respondent. So and so put an appearance on behalf of the respondent number 4. Service is therefore complete. List this matter for admission after 10 days.
Deeply obliged.
Item 20.
My lord, as per last court's order, my lord, I have filed an affidavit, my lord. The Khadi board has referred the matter to the government on 3/11/2024. And thereafter, the government also sought some inquiries from the Khadi board. But till that, my lord, the government has not taken any decision, my lord. I have already retired from service on 31st.
When called to the petitioner, Helen indicating as to when the Khadi board has referred a measure promotion to the government. You have filed this.
Yes,
affidavit.
yes, ma'am.
When it was referred to the,
On 3/11/2023.
when you have filed this affidavit,
On 8/5/2024. 8/5/2024. I filed the additional
but it is not available on record.
check, my lord.
Then council has submitted that he has already filed an affidavit pursuant to the order passed by this court on 26/4/2024. However, the same is not available on record. Office is directed to check. And if the affidavit is filed, the same be tagged along with the record. This happen for admission after a week.
This is a contempt case, my lord.
Item 21.
I think it is order, my lord, contempt case.
Come to order. Order में आए.
Acha, orders. Let's go there.
Very pleased, your lordship. The contempt, minor petition for initiating contempt proceeding against the contemners for violation of the common order dated 24/1/2023, man.
Yeah, read that order.
That was a page, 11%, page 30, man.
Yes,
Page 30, man, para 4, man.
the only issue, para number two, Siri. You read from para number two.
Yes, madam. The only issue raised in this appeal is as to whether the private respondents satisfy the eligibility criteria as on, as on the last date of submission of applications for appointment to the post of Sahayak in Assam Power Distribution Company Limited. It is the contention of the writ appellant that these private respondents did not process the same. It is now well settled that if any candidate does not possess the requisite qualification as on the last date of submission of application or on the date as may be fixed by the authorities, any selection or appointment of such person to a public post will be in violation of Article 14 of the Constitution of India. Direction given, my lord, is from para 4, my lord. Under the aforesaid circumstances, we direct the respondent PDCL to conduct a verification exercise of all the persons who were appointed to the post of Sahayak. And if it is found that if any of them had submitted her requisite essential certificates, documents after the last date of submission of application or the date fixed by the authorities concerned or did not submit such certificates, such persons may be identified and their services will be liable to be terminated. However, only after giving a notice to them. After completing the aforesaid exercise of terminating the services of such ineligible candidates by giving due notice to them, the vacant post shall be filled up from among us the remaining other candidates as per the merit. And if any of the writ appellants come within that zone of meritorious candidates, they certainly shall be accommodated as per merit to the said vacant post on termination of service as
Selections
mentioned
took
here.
place in which year?
My lord,
Selections took place in which year?
my lord, in the year 2014, my lord,
2014.
14, my lord. What is the contempt here? For violation of the common order directive. Which is the order? Which part has been violated? You'll also kindly see in my lord, the last part, my lord. It is directed that, my lord, appoint to the post of, my lord, verification exercise of all the persons who were appointed to the post of. It is directed to verify all the persons who were appointed. But due the course of argument before learned division based, my lord, learned standing council appearing on the PDCL. What is the violation according to you? No verification is made as of now, my lord. Where is the statement? Where is the statement in your petition? So, my lord, we have made an application on. Where is the statement in your petition? No, we simply says, my lord, is a clearly violated the, my lord.
Until and unless you make out a case for willful disobedience, where we can, how can we issue a notice in the contempt petition? And ultimately, the contempt, this order was passed on.
24/1/2023.
Now you are appearing in, filed this contempt petition in May 2023. What about that 1 year limitation?
Yeah, 1 year, yes, my lord, because on 31, my lord, on date, after opening the certificate, we submitted the same to the concerned authority on 24/3/2023, my lord.
Yes.
My lord, then after on 31, it will submit an application under RTI.
That can't extend the limitation, sir.
Seeking, my lord, action taken, whether any action taken pursuant to the honorable court's order.
There is a question of willful disobedience.
Then on 2012/2023, they said, they replied that, my no. The contempt number 3 intimated the same to the contempt number 3 and requested him to furnish information whether any action taken pursuant to the court's order date 24.
Then what happened? Then what happened?
You know, it's not yet provided, my lord, not yet provided information whether they have taken any action pursuant to the common order, my lord. It is apparent on the face of the record, my lord, during the course of argument on a division based, my lord, not in standing council appearing with the application, clearly says some of the candidates who were appointed, my lord.
Your case is that no verification has happened as per the court's order.
Yes, my lord.
You have not made a statement in your petition to that effect. Is that correct, Mr. Ahmed? If that is correct, there is no case of contempt here. Will
Yes, my lord, we have said, my lord, that after,
You have simply said, yeah, I have moved an application under RTI and they have not furnished any information and therefore you have presumed that they are not compliant with.
no, no, my lord, we clearly
There is no
stated
such-
that, my lord, despite the order by the Lane Division Bench, we submit the same, but not yet, my lord, complied with. They have said, my lord. Despite the repeated requests made by the petitioner, that has not yet been complied with as of now.
Contention, the contempt without providing any information to the within 1 month from the date of receiving it, inform the petitioner by letter dated so and so RTI application has been forwarded to control and request has been made to provide. Therefore, it can clearly be said that the content has willfully deliberated violate a verdict, nothing else. This is since the one of the respondent has informed you that I have already written a letter to so and so and therefore there is a willful disobedience. This can't be the willful disobedience.
That is 12/10, 2023, my lord.
Look here. This contempt petition is filed by the petitioner complaining that.
You also mentioned, what is my lord, it is, my lord, it is a fact, my lord.
24th of January 2023 in writ appeal number
308 of 2020.
308/2023 has not been. 21 has not been complied with. 308/21 has not been complied. Full stop. Para. This court by the order dated 21/2023 issued a direction to the respondent, to the Assam Power Distribution Company Limited to conduct a verification exercise of all the persons who were appointed on the post of Sahib. And as further directed that if it is found that any of the candidate is filed his oblique her requisites essential certificate documents after the last date of submission of application of the advertisement concerned, their services are liable to be terminated. However, after giving notice to them, it is further directed that after completing the exercise of terminating the services of such ineligible candidates, the vacant post shall be filled up from amongst the remaining other candidates as per their merit. If they come within the zone of meritorious candidates. Full stop. And council has submitted that the said direction has not been complied with by the respondents. We have gone through the contempt petition as well as the affidavit filed in its support of it and found that there is no specific government of this effect that the authorities of the APDCL has not conducted the exercise as directed by this court by the order dated 24/1/2023. The petitioner in this contempt petition is relying on some communication received by him from respondent number 52. From respondent number 5 to the effect that he has written a letter to the respondent number 3 to furnish the information regarding the action taken by it, full stop. And therefore, it can be said that the contemners willfully and deliberately violated the judicial word, full stop. We are not convinced with the submission of the learned counsel to the petitioner and are of the view that the petitioner has failed to make out a case of willful disobedience on the part of the respondents, hence no case for issuance of notice is made out. Contempt petition is dismissed.
Right. It will be petitioners, sir. Petitioners.
Item 22.
May I be lordship? Sir, office note dated 3/5/24, service notice is awaited in respect of respondent number 1, 2, 3, and 8, my lord.
Yes, 1, 2, 3, and 8.
My lord.
They have served.
We have taken step, my lord. We have taken steps. Service
taken
notice is awaited,
steps.
my lord.
What happened to neither AD nor receipt for 1, 2, 3, and 8 has been till that is of 15th of March 2024.
My lord.
Take fresh steps.
My lord, I will take a test.
And consider the applicant. Yeah, as per the office report, notices issued to the respondent number 1, 2, 3, and 8 has not been received till date. Stop. Then it consider the applicant is directed to take fresh steps for service of notice upon the respondent number 1, 2, 3, and 8 by registered daily within a period of 2 weeks.
All right.
Item 23.
May it please your worship. There's a condemnation application memo, 32 days of delay,
Fresh.
fresh. The 80-plus-old lady, sometimes taken to come to Guwahati and all.
You are appearing?
Yeah, please, my lord. My lord, we have no objection to the delay.
You are appearing for all the respondents.
No, my lord, respondent number 2, 3, and 4.
What about 1?
I am representing on behalf of respondent number 6. 5 is the accountant general. They have their own counsel.
And what about
All
the
government people,
respondent number 1, Union of India? Why you have made the Union of India?
because REC Silchar subsequently became NIT. It was co-funded by the central government and the state government. To that extent of the pension, it would be required.
Yes, Mr. Union of India Council.
He can appear for 1 and 5.
Since 32 days, no, that's.
1 and 5 you can appear. Central government. What is Accountant General Nagaland?
Initially, I was working in Nagaland. Thereafter, through proportion, I came to here. Now, they calculated that part of
Is it a Accountant General of Government of Nagaland?
Tamil Nadu.
How can it be? Accountant General is central government.
It will be.
Government of Nagaland. The matter comes upon for consideration of the application with the fair to condone the delay of 32 days in filing the connected appeal. Stop. Mr. Roy Chaudhary is directed to accept notice on behalf of the respondent number 1. So is appearing on behalf of
Respondent number 2, 3, and
2, 3, and 4. And Ms. So-and-so is appearing on behalf of respondent number 6. The respondent number 5 is a formal respondent. Having heard the learned concept of the parties and also going through the contents of the application, we deem it appropriate to allow the allow this application. Hence, the IA number 2 is allowed, delay of is condoned. Registry is directed to register the writ appeal, connected writ appeal, and list before this court up to 2 weeks for admission. In the meantime, counsel for the applicant is directed to supply a copy of the writ appeal along with the requisite documents to the counsel for the respondents. List after so and so, while showing name of the counsel for the respondent.
That has
Reflecting
already
the
been
name of
supplied.
the
In fact,
Counsel for the respondent in the call list.
For admission, item 24.
Yes, who is for the petitioner, Mr. K. Barua.
I am for the respondent, my lord.
Who is for the appellant?
Appellant, my lord, he was there, my lord, complete. I
Seen, my lord. Lovely.
Also for the timing. For the timing.
Item 25.
May I appeal, your worship? My lord, the issue involved here, my lord, the Panchayat term has been expired. And my lord, on the other hand, they have not, my lord, hold the election. Now, identical issue, my lord, raised before this honorable court. And this honorable court has held, till the election is held, my lord, the earlier body should continue
By way of an interim order.
by final order in a different case.
Where
In
is
the
that order?
previous year.
Where is
Yes.
that order?
That your lordship will find at page 52.
52.
Yes. And operative part lordship will find
52.
at page 57,
Just a minute.
page 52, my lord, starting.
In 2006.
Yes.
Okay.
Then, my lord, page 57, the operative part of the, my lord, direction, lordship will find para 14.
Yes.
Basically, my lord, para 14, D, my lord.
Yeah.
The Gaon Panchayat, Anchalik Panchayat, Jila Parishad, whose terms have been expired because of the failure on the part of the state respondents and so election commission to fulfill the mandate of the constitution to hold the election before the expiry of their term shall be allowed to function till the new constitution of the new Gaon Panchayat, Anchalik Panchayat, Jila Parishad, after completion of the election. But they are not allowed to take any major policy decision, make an expenditure from the funds other than the payment of their salary of the staffs and routine function of the office without permission of this court. That was the earlier judgment passed by this honorable court in the same facts and issue involved as well as involved. Now, here your lordship will find the impugned order. In the present case, we have annex. Lordship will find at page 93. This is common judgment and order. Lordship will find the operative part at page 1 on 3.
Para.
Yes. And the judgment lordship will find operative part at page 147.
Para.
Yes. Para 45, my lord.
45.
45.
Yes.
This court is view is of the view that the source of power to sit in the office.
Where the court has this
Page 46 minutes.
discussed about the case which you have referred to?
That has been
That has been referred, my lord, discussed in paragraph 44.
44.
44. This court is agreement with the views expressed by the aforesaid case of the Pub Mongolai Anchalik Panchayat Supra. Further, that from the facts under which the case of the Uttur Demaji Supra was deciding being distinguishable, the said decision also appears to have been rendered on the basis of the certain decision on certain administrative default quota service law. It also appears that the aforesaid decision was rendered without taking into consideration of the Article 243E1 of the Constitution of India. In any case, it is constitutional mandate as to hold, let down the Article 243E1, which will prevail. Next, para 45. This court is of the view that the source of power to sit in the office of a panchayat in the mandate given by the people as voters, and that mandate is only for the period prescribed in the statute holding the field. This fact is fortified by expression used by the constitutional makers in inserting the word and no longer Article 243E1 in absence of such mandate after expiry of the term prescribed by law. In the opinion of this court, the petitioners would not have any enforceable right to maintain the present challenge. In fact, every locus of the petitioner to maintain the present challenge would be questionable. The election to the panchayat being a part of the constitution, which is the cornerstone of the democracy, the authority bestowed the election upon the petitioners who are elected representatives and had ceased immediately upon expiry of the term. This court has also noted that there is no provision for extension of the term in the Act of 1994, and in absence of any such provision, no right whatsoever would be accrued upon the petitioner to continue as president, members of the respective panchayat after expiry of the term. Now,
Yes, that's all.
yes, then my lord, para 46. My lord.
Yeah.
Yes, para 46. The my lord, Surya Pukon, that has in respect of my lord, the municipalities.
Interim order. Interim order,
Surya Pukon. Yes, that is in respect of my lord, municipality.
but that was an interim order.
Yes. And my lord, page 50, my lord, the final paragraph, my lord. It says, my lord, only my lord, petition is dismissed, but the election authorities are directed to hold the election. No time frame is given, my lord.
Time they let them complete with this parliamentary election, then only they.
But yeah, that's fine, but at the issue is, my lord, one coordinate bench allowed the writ petition.
That judgment is not in consonance with the law, which you have referred.
Yes, that was,
That is, that you can't even continue for a minute after expiry of the term. Ultimately, you are elected for a period of 5 years, that on completion of 5 years, we have to vacate the office.
yes, that is our limitation. But so far the election commission is concerned, they are really want to hold the election before expiry of the term. That has not been.
Yeah, that's right, they were duty bound, but that doesn't mean that you may, you will continue.
But had it been, my lord, election had been held in a, my lord, before expiry of the term, the local bodies, my lord, that cannot be the property of the panchayat,
The
cannot
court
be.
has already ordered for it. What remains? Nothing. This writ appeal is directed against the, directed by the appellants, being agreed with the orders.
Similar. Okay.
The judgment dated 22/3/2024, passed by the learned single judge in WPC number 762/2024 and other connected. Yeah, there was one petition or other connected petitions were also there.
Well, other petition, common judgment and order.
A writ petition number so and other connected writ petition. Whereby the writ petitions filed by the appellant along with the other writ petitions have been tested. The petitioners, the appellant
Yes.
are the your sarpancha or what gaon mukhya? What it says? The petitioners were, the appellants are the elected presidents. You're the president of the,
Yes, President, my lord.
president of the Gram Panchayat concerned. And has filed writ petition being agreed with the action of the state government, whereby after expiry of the term of the Gram Panchayat, the administrator have been appointed, or the district commissioners were taken over the charge. What direction was given?
Already district commissioner has given
The
the
district
authority.
commissioners were directed to take the charge of the Gram Panchayats whose terms have been expired. Stop. The learned single judge has dismissed the writ petition while taking into consideration that as per section 7 of the Panchayat Act, Assam Panchayat Act 1994, the duration of the section 7, the duration of the Gram Panchayat is 5 years from the date of election. The learned single judge has also taken into consideration the provisions of Article 243, which specifically says that every panchayat shall continue for 5 years from the date of its first meeting and no longer. Full stop. The learned single judge has also relied upon the decision of the Honorable Supreme Court rendered in Hemant Narayan Rasane versus Commissioner and Administrator of Pune Municipal Corporation, reported in 2022-18 SCR 180, and has held that since the term of the petitioners as Gaon Mukhya of the Gram Panchayat has already expired, they cannot claim to continue on the said post after the said expiry. After the said expiry as a matter of right. Having heard the learned counsel for the appellant and after going through the impugned judgment, we don't find any illegality in the same, hence this writ appeal is dismissed.
Your appellants are all presidents, members of Gaon Panchayat, Anchalik Panchayat and Zilla Panchayat. इसमें अच्छा here only Gaon Panchayat.
Only one petitioner, my lord, president of the Gaon Panchayat.
Gram Panchayat.
अच्छा, another thing, 5 years from the date of
From the date of first meeting. First meeting.
Issues were similar to some years of.
Item 26.
My lord, Her Lordship will find, my lord, the impugned order at page 65. It is, my lord, a cover case by the, my lord, judgment, my lord, the interim order passed by the Honorable Court,
65.
page 65. Now, this is against the, my lord, common judgment and order, and other issues are pending before the Honorable Court. And some of the, my lord, writ appeal, my lord, this court was pleased to pass an interim order.
Relinquishment. Not relinquishment. Relinquishment.
Relinquishment. Relinquished deed is not relinquish. Same order, yes, ma'am.
I can notify the
Should notice. We can concept for the appellant and submitted that in identical writ appeal, this court was pleased to issue notices to the respondents and has also passed an interim order to stop. issue notice. To take away the understanding concept, all these respondents which are you are referring on this, but if you take away the understanding concept, higher education department, Assam. Higher education department, how it is?
Because it is relating to the college. The land is equity for the college.
That construction of college is going on.
But it is now, as on date, it is stopped.
Why? On account of this?
Because they are seeking another site to construct the college.
But the building is already around 30% is complete.
30% complete.
Despite that, they are.
Despite that.
Or they have stopped the work on account of stay order by.
Not account of the interim order, but because of the site is not proper as inquired by the departmental authorities. So they are seeking another site.
After construction of 30% over the.
Yes.
30% construction is over.
Yes.
Yes. What's your instructions?
Regarding this, I will have to seek instruction regarding the construction status of the construction from the deputy commissioner. আপনি কোনটো
कंस्ट्रक्शन कैसे कर दिया
Yes. Apa kita hasil atau 2 weeks? 1 week.
So February 2024, the learned single judge observed that 39% of the work has already been completed.
I have been instructor 30% work has been completed. No? 39%.
39% in February.
Yes.
Now it's 3 months have passed. Ultimately, you can ask for compensation, but so far as regarding construction of building of college, we can't stop that. Pass the interim order. Notice, Mr. So-and-so. He is made of. This writ petition along with, read this writ appeal along with. Writ appeal number 94/2024 on 3rd of June. On 3rd of June. In the meantime, the concept for the estate may filed a factual report regarding the status of the ongoing status of the college building, detailing out that how much work has been completed.
Right, sure.
List so and so, while showing name of so and so. You just give the dates on that.
Item 28,
Relinquishment deed. Relinquish the deed. Yeah,
My lordship, this rules has not been followed, my lordship, as per the relevant rules, my lord. Full name.
which rule has not been followed and where are those rules?
Page 30, my lordship.
Page
31, page 31, may be seen.
31.
Type copy is page 30, my lordship.
Yeah, read.
My lordship, the inspector of schools, after consultation with the principal, head, master, and local people will forward two names to the director, secondary education Assam, for each president and vice president with the recommendation of deputy commissioner within a period of 30 days. After considering the names, director, secondary education Assam will provide the list to the government with his comment for selecting single name after comparing data of both candidates, and the government will approve the committee. The terms and the conditions, including grounds of dissolution of SNDC, shall remain the same as mentioned in the government notification number 34. My contention is that, my lordship, the data has not been compared, my lordship, and private respondent.
Comparing data of both the candidates and will approve. They will approve the committee.
Yes, please.
So.
No
now
such
they have not
process.
compared the data.
No, my lord, no such process has been done, my lordship. Four names has been recommended, my
But the
lord.
learned single judge gave a finding that there is no, the procedure has been followed.
My lordship.
It has been given.
My lord, compare, data has not been compared, my lordship.
Yeah.
Four names has been forwarded by the committee,
And out of which one was selected.
also one was selected.
So
And,
what's wrong in that? Simply because your name was at serial number 1, that doesn't mean that you are to be selected only.
my lordship.
That doesn't- That's all.
Yes, my lord.
This writ appeal is filed by the petitioner being agreed with the appellant being agreed with the order dated 2/4/2024 passed by the learned single judge in writ petition number 6818/2022 and 68/2022 whereby the writ petition filed by the appellant has been dismissed. Full stop. The appellant has preferred the writ petition being agreed with the appointment of the respondent number 6 in the writ petition as president of the School Management and Development Committee of which school
My lordship.
of Pamun Dongra Higher Secondary School. Full stop. The learned single judge, after scrutinizing the material available on record, has come to the conclusion that the respondent number 6 of the writ petition satisfies the criteria as mandated in the notification dated 24/6/2016 for being nominated as president of the STMC concern. And the petitioner has failed to make out a case that the procedure laid down has not been followed in its letter and spirit. Full stop. The learned single judge has also observed that the appellant has not leveled any allegation of malafide against the deputy commissioner or the guardian minister of the district. Learned single judge has further observed that when the procedure laid down has been followed and the procedure laid down has been followed, this court, while exercising power under Article 226 of the Constitution of India, is not required to go into the merits of the decision. And when the decision process is without suffering, is not suffering from any procedural irregularity, the same is not liable to be interfered with. Full stop. Learned concept of the appellant has failed to persuade us to take a different view, and we don't find any merit. The same if they put this.
Highly obliged, my lord.
Item 29.
May it please your lordship. My lord, I beg to appear for the appellants in this matter. Am I audible, my lord?
Yes, you are audible.
I'm grateful, my lord. My lord, the impugn order is a common order passed by honorable single judge, my lord. And the writ appeal arising out of that order, which is posted for admission hearing.
1 minute.
Just a minute, hold
My-
down.
Lordship, if I may,
Hello.
I realize this is a VC call. Lordship, can this matter be taken after some time? Arguing counsel is on legs. My humble apology, Lordship. Can this matter be taken after some time?
Yes, Mr. They are seeking for Passover.
My lord, okay, my lord. I'm agree to. I'm great.
Passover for the time being.
Item 30.
Let be your lordship. My lord, no, this is against the order of the.
MSB Sharma appears for the respondent, Lordship. Lordship, can it be taken up after some time, Lordship? Please just ask me, pass over for the finding.
Concept. Council आ जाए तो-
Come, Lordship, after some time, 10 minutes.
For the time being.
Right.
Item 31.
I'd like to issue notice at this stage, my lord.
Already
Yeah.
issued notices in some. of
Yes,
the-
my lord, 2163 of 2024. And it is fixed on 24/6/24.
Issue notice. If somebody was appearing on behalf of the state in that,
I appear on behalf of respondent number 4 and 5.
what about the others?
I think all government advocates can take notice. These are all official respondents.
Who are those government? Yes.
These are all government advocates.
I'm appearing for 1, 2, and 3, Lordship.
1, 2, and 3.
Yeah.
And 4, what about 4?
4 and 5 Lordship, I appear.
You are appearing. Issue notice. So-and-so, Miss so-and-so is appearing on behalf of the respondent number 1, 2. 3, Mr. So-and-so is appearing on behalf of the respondent number 4 and 5. No formal notices be issued. The concept of the respondents may file their response to the writ petition by the next date of hearing, put upon 24th of June 2021, along with the writ petition number
2163 of 2024.
2160 of
2163 of 2024, na?
2024.
Yes. My lord, may I pray for a notice on the interim order after they file their affidavit, my lord? Because we are out of job.
You may file out of job.
Yes, because by virtue of this, my lord, the registrars are out of job.
Yeah, instead time on the last occasion, we asked them to have some arrangement for that, and the court, the concept of the respondent has assured that we'll do something in between. Let us see.
On next day, lots of.
Next, we'll see.
Deeply.
Item 32.
May it please your lordship, as per order dated 26/4/24, lordship, respondent were directed to take instructions as to what steps were taken after the submission of the inquiry report.
Just what was the
Well, I have received the instructions from the Deputy Commissioner Shivsagar and the SP Shivsagar, my lord. So after receipt of the inquiry report in the Amguri PS case 6 of 2024, the police has added 409. Otherwise, earlier, my lord, it was 409 IPC was not there. Now they have added 409. It is, my lord, criminal breach of trust by public servant, my lord. But
file your affidavit?
we'll file, my lord. We'll file. I have received the instruction. We'll file that.
BK, Mr. Nath has submitted that the Superintendent of Police Shiv Sagar, pursuant to the direction, pursuant to the report, inquiry report furnished by the Superintendent of Police Shiv Sagar, a case has been registered against the erring persons under section 409 CRPC, IPC, along with the other offenses in PS case number, Amguri PS case number 6/2024. Stop. He has submitted that Mr. Nath has prayed for a week's time to file additional affidavit of this effect. Time period for his granted. Will start training.
Item 33.
May please your lordship. Well, this EIL is in respect of the stone crusher units in Qatar and Karimganj district, where, my lord, the stone crusher units are illegally crushing limestone, which is not permissible. And as a result, two things have happened. One is,
Similar matters have already been dealt with by this court. is it?
yes, my lord.
Yes, sir.
Where are the orders?
That order I have, I don't know if there is any other pending matter. Earlier, your lordship, sitting with the honorable chief justice, has passed an order that your lordship will find that I have annexed that. That is at page 67, transcript page 79.
There, your lordship has passed a notification by which the stone crushing units were allowed to crush limestone with a lesser point, my lord, lesser degree of its purity, less than 40% of calcium oxide. That was set aside by your lordship in this pair.
Well, this is now what had happened, my lord, the forest department, my lord, the regulates these crusher units. But my lord, these units are now taking licenses from mines and mineral department and crushing in the crushing units, my lord. Forest department basically has no role, my lord. We have tried to stop them, my lord, but they have said that no, we don't want your crushers. We have a separate permission from mines and minerals, so we are going to crush limestone, my lord. That is going on, my lord.
That's why you have made the, my lord, the director of geology and mining also a party, my lord.
Notice. So so put in appearance on behalf of the respondent.
I am for 1 and 6, 1 to 6.
1 to 6. What about the other respondent?
7 to 11, I am appearing.
7 to 11.
11.
20 7 to, Mr. So is appearing on behalf of the respondent number 7 to 11. Let notices be issued to the respondent.
12 to 41.
41.
12 to 41, all the one crusher units.
12 to 41. Registered date, that's the 4 weeks.
Okay.
6 weeks.
All right.
Registered date, that's the.
Right. 1 to 6.
Item 24.
Here, your lordship. Earlier, the petitioner was before this honorable court, your lordship. And the honorable court, your lordship, taking note of the submissions made by the authorities, your lordship. If your lordship comes to page 233, your lordship. Order of the honorable court, your lordship. In earlier round of litigation, your lordship.
233, yeah.
Lordship. And if your lordship.
So,
Lordship, there, your lordship may kindly come to page 227, your lordship. 227, the inquiry by the retired honorable judge of this honorable court, your lordship. And thereafter, your lordship, we filed Art 227, your lordship. This is by the honorable governor, your lordship, and chancellor, AAU, your lordship.
thereafter 220.
Thereafter, your lordship, we filed an RTI, your lordship, asking them for copy of the what has happened, your lordship. They informed us that, your lordship, page 234, your lordship. It was November 2, 2022. I am to inform the inquiry committee constituted by honorable chancellor has submitted the inquiry report. This office has communicated for views and matter is under process at present. And then, your lordship, what has happened, we don't know, your lordship. That's why we are before this honorable court, your lordship. And in fact,
By the way, who are you?
lordship, in earlier round of litigation, your lordship, I was the petitioner, your lordship, who have raised these issues, your
Who
lordship.
are you? What is your status? What you are doing?
One petitioner number 1 is an advocate, your lordship. Para 6, your lordship.
Petitioner number 1 is the advocate. Petitioner number 2 is
2 is a, your lordship, retired government employee, your lordship. He retired from
of that university.
lordship.
University employee.
No, your lordship.
No.
He does not belong to university. He is a citizen, your lordship. He has come, your lordship, coming to know about these allegations, your lordship. And your lordship, the honorable chancellor, your lordship, by taking note of the serious allegation, your lordship, constituted a committee, your lordship, of the headed by a retired judge of this honorable court, your lordship. And this committee submitted a report, your lordship.
How many?
And in a
whether
patient,
These petitioners have filed how many PIL petitions?
Lordship, this was the second, your lordship. Earlier he has come.
In relation to the, otherwise, there
No,
are no other.
no other, your lordship.
In all other public matters, you are not.
No, I have not, your lordship. Only on this issue I came.
Saying in all other public matters, public related matters, you are not concerned about that. You are only concerned about the this university only.
Lordship,
Because there are so many problems
Lordship,
facing
that-
the public
that is-
at large. So whether you are a social worker, a crusader, or what, whistleblower, or what you are.
Lordship, when I came to know about this, your lordship, then your lordship, I came before this honorable court when your lordship.
We just want to know that how many public causes you have raised till this date. Because petitioner number 2 is 71 years old.
Lordship.
He might have experienced
Lordship.
how he is raising the public concern.
No, your lordship will kindly see, I came before this honorable court, your lordship, for the first time in this case, no doubt about that, your lordship, and I have not taken.
Thereafter also, you have not filed any such petition.
No, your lordship, I have, so far as my instruction goes, your lordship, I have not been given that instruction, and I have not also asked for this, your lordship. And I came before this honorable court, your lordship, solely because, your lordship, this is a public money, your lordship, in respect of which.
We just want to know that
Lordship.
in many areas, public money is wasted like anything. Then how many questions you have raised regarding this?
That, your lordship, so far as that, since this has come for the first time from this honorable court, your lordship, I have no instruction on that, your lordship. I will have to take instruction on that. I came present, your lordship, since an earlier round of litigation. Even in your lordship.
You are alleging that they have misappropriated some fund or whatever it may be. Ultimately, it's a cognizable offense. File and complaint.
No, your lordship, there is an FIR, your lordship, laws on that.
Absolutely. One appropriate application before the magistrate court. What happened in that FIR?
Lordship, that's why, your lordship, even your lordship, before that, your lordship, so far as the FIR is concerned, your lordship, there is an inquiry by the, and if your lordship may kindly take up the order of the honorable chancellor, your lordship.
Yes.
Based 227, your lordship will find, your lordship, consequent upon the.
Move an application to the government that you are in receipt of so and so report, what you have done, the government will furnish the information.
The
Move an application.
Your lordship will
The
kindly.
RTI, once you have moved an application
Lordship.
to this governor secretariat, and governor has said that we have already, the secretariat has said that the inquiry report is referred to the state government. Move an application with the state government. What happened to that report?
No, your lordship will kindly see, since
We
this.
are not for here to provide you the information or ask them to.
No, your lordship, that is not about information, but your lordship, since we have come here, your lordship, since this honorable court granted us a liberty in earlier round of litigation.
What liberty?
It says, your lordship, consequently, we presently cause the PIL with an observation that subject to the result of the inquiry and investigation in the FIR, the petitioner would always be at liberty to approach the court in future by filing appropriate application, your lordship. This liberty was granted, and your lordship will kindly see a project, your lordship. 60.
Result of the inquiry and the investigation in the FIR.
Lordship.
The petitioner would always be at liberty to approach this court in future by filing appropriate application.
Lordship.
So still you are not aware what is the result of the inquiry and what is the result of the FIR, and you immediately file this petition.
No, not immediately, your lordship. Your lordship will kindly see.
Or immediately or with after some time or after
Around 2
many
years.
But ultimately, result of the inquiry and the investigation in the FIR, then only the liberty was granted to you.
Yes, your lordship, inquiry was conducted, your
For
lordship,
that reason, you
completed
are seeking
report.
this information, what happened to the inquiry report? Now you are saying that another PIL.
No, your lordship will kindly see November 2.
Application, appropriate application before the government seeking information, what happened to that report, that's all. And so far as regarding FIR is concerned, you can very well move to the concerned court that what happened in that FIR.
Your lordship, we were told, your lordship, before the information commissioner, your lordship, that they are unable to provide the copy of this inquiry report, your lordship. That I have annexed at page 235, your lordship. The order of the Governor Secretariat, your lordship. He is hereby to provide the available permissible information related to matter within 3 weeks. However, the applicant has been briefed verbally about the status, stating that views, different related angles of matter have been obtained and matter is under process.
Move application to this state government.
We came because, your lordship, this liberty is granted, and secondly, your lordship, a project,
That
your
liberty, ultimately, the inquiry report is there and the FIR in the fate of FIR, then only you are granted that liberty.
100 crore has been, your lordship, spent, your lordship, without tender, your lordship. And your lordship, the project initially was
Subject
62
to the
crore.
result of the inquiry and the investigation in the FIR.
Lordship,
So
that is what,
subject result.
that is why, your lordship, I have to sought, your lordship,
Not
copy of the
second
RTA.
PIL, not second PI. This PIL country.
It involves public money, your lordship. That's why we am
That's
before.
why only we were concerned about that, how much issues regarding misappropriation of public money was raised by these persons. These petitioners.
Lordship, suppose, your lordship, we have not, your lordship, raised
shows
any
your
other
bona-
issue, your lordship.
that
Will it disentitle me from raising this
That
issue,
shows
your
your
lordship?
bona fide, certainly.
Your
not.
lordship.
But.
And I am
that shows your
otherwise no way connected with the affairs of the universities. In some way I connected, then, your lordship, my bona fide may be questioned, your lordship.
See, Mr. Botaku,
Lordship.
try to understand the query made coming from my lord. You see, let us assume that it's a bona fide petition and you're espousing public interest. Even then, the allegation basically is one of a cognizable offense.
Lordship.
Once the mechanism is put into motion, Reed Court cannot go in and investigate, correct? Now, some steps have been taken. A commission headed by a retired judge has inquired into it, submitted a report. Ask for the report, find out if something is wrong, somewhere the legal process is derailed, then we can understand. You can't come and tell us that, tell them to give us a copy. We don't know what has happened. That's not the purpose of PIL.
Lordship,
Sorry,
that's not.
we are
my-
not a post box here, post
Lordship,
office.
That's not my prayer also, your lordship.
Yes.
That's,
So what has happened in the inquiry report?
that's why we sought a copy, your lordship.
No, that you have to ask under RTI.
That's, we have sought from under RTI. your
Then file an appeal.
Appeal, your lordship, filed, appeal directed, your lordship, on the basis of that this order has been passed. Your
Then you have to challenge the order of the information commissioner in filing a writ petition.
It is not by the, your lordship, information.
PIL is certainly not a remedy here.
It is not by the information commissioner, your
See,
lordship.
what happens is the PILs are getting unruly completely. These are extraordinary remedies.
Lordship, I understand, your lordship. And we filed this petition, your lordship, only because, your lordship, that it involves a huge amount of money, your lordship, around 108 crores of public money. That's why. Your
There are other bodies, constitutional organs, which are there to look into these things, including the CAG. The inquiry commission is there, report has come.
Lordship.
So if we find that something grossly wrong is happening, it's a different matter. Otherwise, just to help you, unleash a crusade, we can't exercise our
Lordship, I
extraordinary
know,
power.
your
That
lordship.
is not possible.
That's why, your lordship, I have waited for 1.5 years, your lordship, expecting that government will take
Why
action.
not approach the government?
Yes, lordship, we will approach, your lordship, we will approach.
Approach the government. Then only certainly PIL is not vulnerable for that. My lords have rightly pointed out, we are not forced.
No, your lordship, that is not my prayer also, your lordship, in the writ
It is ultimately, this
petition.
leads to only this.
If your lordship finds your lordship after calling for the report that there are gross irregularity has taken place, then they are sitting over the matter, your lordship.
This writ petition is filed by the petitioners in public interest with a prayer to issue a direction to the respondent authorities to conduct an inquiry into the matter by an independent investigating agency of the state government to be monitored by the Honorable High Court and by an independent or by an independent agency of the country like Central Bureau of Investigation to be monitored by the Honorable High Court of purpose may come like regarding the anomalies in respect of construction of city campus of KKHSOU at Khanpada, as well as its permanent campus at Rani in bracket Patgaon. Full stop. It appears that raising same concern, the petitioners have earlier approached this court by way of a PIL petition number 37/2020. However, the said PIL petition was disposed of by the order dated 3/2/2021 by this court, while taking note of that the governor of the state took cognizance of the matter and has ordered for an inquiry by a committee headed by a retired judge of the High Court. Full stop. The court has also taken note of the fact that a FIR has been lodged at Basista Police Station under section 409/420. Stop. Then in consequence, the petitioner has submitted that as per the information received by them through the governor's secretariat, the inquiry report the committee has already submitted its inquiry report to the honorable governor, and the said report was sent to the state government for further action. But till date, further action, it is submitted that the petitioners are not aware about the action taken by the state government. Having heard the learned concept of the petitioner, we are of the view that if the petitioner is not in receipt of, but if the petitioner is not able to, if the petitioner is not able to get any information on the part of the state government in respect of the action taken on the inquiry report submitted by the committee, the appropriate course for the petitioner is to approach the government of Assam seeking information regarding the action taken by it on the said inquiry report. When the matter is investigated by a committee constituted as per the direction of the honorable governor, and a FIR has also been lodged, we don't find any case for entertaining this PIL. And the appropriate courts for the petitioners is to seek information from the government as well as the concerned court in whose jurisdiction the FIR has been filed. With these observations, this PIL petition is closed.
Oblige, your lordship. Item 35.
Appearing in person.
Yes, last time some directions were issued.
Lordship on the last occasion directed the petitioner to give some suggestion.
None present for the petitioner, the petitioner is person, the petitioner in person is not present. Just after 6 weeks.
Item 36.
As per order 12/6/2023, the agricultural department has to make inquiry, and to that effect, it was required to file. That was filed, my lord. Against that one, I have also filed my rejoinder, my lord. On 12, why has my lord, that is 12/2/2024. That is on my part. But unfortunately, my lord, if your lordship, please.
So you preferred an FIR and no action was taken on that FIR.
My lord, so far that part is concerned, in relation to my lord, my prayer made in prayer number 2 and 3, my lord. That's one
Number 2 and 3 of
my petition, my lord, writ petition.
read.
2 and 3, my lord. Prayer number 1.
Para number 1 of the petition,
Yes, madam. Page 15, madam.
page 15.
15.
Prayer. Yeah,
To make an inquiry by the department and subsequently in relation to prayer number 3, page 16, my lord.
FIR dated 25/4/2019.
Nine.
This FIR was lost by whom?
My affair was lost by the department, my lord.
The respondent number to cause action inquiry and take appropriation against the erring of persons in connection with FIR number so and so.
Lordship may,
Now-
Lordship may take into consideration the order dated 12/6/23, my lord.
To
Well-
take appropriate action against the offence causing an inquiry for involvement of loss of rupees 53 lakhs from the public exchequer.
3, my lord.
400 take appropriate recovery and cause being shown upon hearing the parties, please pass the order so and so.
Accordingly, my lord, in relation to that prayer number 2 and 3, my lord.
Yeah.
The Judicial Honorable Court has directed the respondent number 1 to make an inquiry, my lord. That inquiry was carried out by the department, my lord. That was filed by an affidavit, and against that matter, I have also filed an affidavit.
What inquiry, what they have concluded?
Conclusion was such that the documents basing on which the amount has been released by the department to the supplier is a fake one.
Fine.
Subsequently, the involvement in the officers, as per the statement of the respondent, no officers are involved. They are following the due procedure of law in relation to releasing that particular amount to that particular person. And so far, the steps to be taken up against the supplier in relation to my prayer number 3, no statement has been made by them. Nothing has been stated what steps they have taken in relation to my prayer number 3.
Which order you are referring to court?
My 12/6/2023.
And Sharmal and the concept of the respondent. Inquiry has been completed and the report has been, Mr. B. Chaudhary agreed shall take instruction placed on record the aforesaid inquiry report within a period of 4 weeks. So who is from the agriculture department? Mr. B. Chaudhary. Yeah.
Lordship, that report we have already brought on record in our additional affidavit dated 28/8/2023.
What is in that report?
Lordship, with regard to the certificate that he is alleging that it was fake, which was brought into the tender floated by the Assam Seed Corporation, that was not required at all because the requirement of the document to be filed with the tender, that was never mentioned. That was the one of the conclusion that they arrived. And secondly, lawsuits on the since there was no complaint against the seed supplied to the Assam Seed Corporation, so they have released the amount that was due to the private respondent, lawsuit. And the person that the allegation is being made, he is not a partner of that firm. And the other aspect, lawsuit, that was under investigation since the FR was lost by the Assam Seed Corporation, that was under investigation by the police, lawsuit. That was the conclusion. And from on those points, with regard to the investigation that is going on, they have refrained from making any comment.
You have filed this affidavit along with? You have
Along
filed
with the
this
report, lordship, page 368,
368.
and that's a conclusion part, lordship.
Just.
In page 361, the issue was.
Just.
Conclusion.
Private respondents are appearing.
Yes, Lordship, on the last occasion they were there.
Who is appearing for Dhanraj?
Dubey, R. Dubey law.
Setup fish dealer है. Let him log in. वो तो हो गया already. So what do you want now? The court to investigate the matter?
That part, so, ordered at the 22/3/23, my lord. It's an important, this is passed by the Honorable Court. By that order, my lord, 22/3/2023, my lord. And that affidavit filed with the respondent is incomplete one.
As Chamaria learned counsel revision essay shall file pertinent and explain his steps taken in respect of player number clause 2 and 3 of the PIL petition. Yay?
My lord.
So,
So for, prayer number 3 is concerned, my lord.
yeah,
Nothing has been stated by the,
player number 3 regarding recovery.
recovery.
But they, in their report, they have said that the seeds have already been supplied and distributed to the farmers. Then where is the question of recovery of that amount?
Now, my lord, Lordship may take into consideration the statement made by the respondents in relation to the documents which basing on which the amount has been released. Now, my lord, the respondent number 8, who their affidavit has stated that he has not submitted that particular document which I am relying upon. He stated that once particular document has been submitted before, my lord, at the time of supply of that document, I have filed a RTA application to the Uttar Pradesh seed certification agency. From that, my lord, I have also found the documents which has been relied upon by the respondent number 8 has also been found fake, my lord. I have annexed the documents in that regard. Lordship may take into consider affidavit filed by the respondent number 8. But
by
the
the way,
document which is
the-
relied upon by the respondent number 8.
What the petitioner is doing,
Madam,
You are what? What is your profession?
madam, I am a businessman, madam,
You are a businessman.
businessman, but so far,
Not doing in the same business
no, madam,
of supplying seeds and
No.
all.
no, madam, I'm
Then-
not in that business particularly.
So what is
I-
your business?
I am actually dealing with my fish, madam,
You are
Fish.
dealing with the fish.
fish.
And these seeds are required for what?
Because for farmers, that is not related to my business. That is not related to my business. Also, taken into consider affidavit filed with the respondent number 8, madam.
Who is the respondent number 8?
Respondent number 8 is the supplier, madam.
Okay. So what is his affidavit?
By affidavit stated, the documents which I am relying that it is a fake document have not been submitted by him.
You can,
Number one.
yes.
Number two, the documents which the respondent number 8 has relied upon at the time of supplying the articles, that was not that was taken into consideration by the department. But documents which have been relied upon by the respondent number 8, when I have verified through RTA application, that documents are also found fake, my lord. That was not issued by the competent authority. Even, my lord, the respondent authority has, department, my lord, has also not stated anything about receiving such particular document. And, my lord, pointing out that document which is relied upon by the respondent number 8, my lord. At the time of
So
supply,
far as regarding this payment of whatever the amount is concerned, the query report suggests that he has supplied those seeds and seeds were distributed to the farmers. And thereafter the payment was made. In relation to your complaint, CID investigation is already going on. Now, what else you want?
Right.
We can't direct
Right.
them to recover that amount from him unless the inquiry it is found that this person is guilty.
so far this part is concerned, as per the respondent number 8, as per the respondent number CID department and the supplier and the department itself, some officials are involved in that, my lord.
Have you made those officials as party?
No, madam. They are not particular. Let the matter be inquired by the concerned authority, that is the CID authority. I have no objection to that effect, my lord.
So the concerned authority has already
Making-
come to the conclusion, additional secretary, government of Rajasthan, the government of Assam, agriculture department, that since the matter is investigated by the CID, I don't offer any comment on it.
My lord.
So let the inquiry be continued with the CID and
That may be, my lord, completed, because since 2019, my lord, matter is pending, my lord,
Yes.
before the authority, my lord. Or an affidavit has been filed, but even as on today, my lord, I have not been examined by the authority, by the CID authority.
but that is if it is necessary, that is for the
that
investigating
is-
officer,
that is
whether
admitting
your
your
statement is
authority will
necessary
say,
or
my
for
lord.
that purpose, even
Even, my lord, so far, my lord, other parts is concerned in relation to, my lord, making, my lord, submitting, my lord, false document, whatever it may be. If, my lord, the department, my lord, CID branches, my lord, makes an inquiry in a, my lord, speedy manner, that will be, my lord, better for all, my lord.
they have already concluded the inquiry, sir.
My lord.
What else then?
And so far, my lord, department finds that some documents have been, my lord, manipulated by the supplier, basing on which, my lord, the farmers
That
are-
is the subject matter of the police investigation. Ultimately, the police will conclude, then only they will take action against the person.
But so far, section 11 in relation to, my lord, submitting fake documents is concerned, department ought to have, my lord, taken even, my lord,
Supply was already completed. The allegation was police state CID is conducting investigation. So let the investigation proceed and proceed to the land. Within a reasonable time. Thereafter, in accordance with the necessary steps. That's it.
one thing, may I, my lord, if you would also punish, my lord, may I point?
Yes,
And so far the supplier's role in supplying the materials is concerned, madam. The department is maybe not directed to take action or so cause notice in relation to section 11 of the Procurement Act. So that madam, he cannot madam do anything in future in that regard.
No, what?
Yeah.
Nobody was involved in
Okay. This public interest petition is filed by the petitioner, essentially raising a grievance that the respondent number 8 was granted a contract for supplying of seeds. Which seeds are this? Pea seeds.
Please,
Pea seeds by the Assam State Seed Corporation Limited. Though along with his bid, the respondent number 8 has furnished a board's accreditation certificate board germination certificate, na? Germination certificate. Stop. The petitioner has sought directions for the respondent number 5, 7, and 8 to cause an inquiry and to take appropriate action against the erring persons in connection with the FIR. Your FIR is lodged by you.
No, my lord, by the department.
In connection with the FIR lodged by the department. It is also prayed that the respondent 4, 5, and 7 be directed to take appropriate action against the officials of the Assam State Seed Corporation.
Yes, my lord.
To ascertain the involvement of the persons who caused loss to the public exchequer. It is also prayed that the respondent number 4, 5, and 7 be directed to recover the embezzled amount. It is noticed that during the pendency of the writ petition, the government of Assam Agriculture Department has conducted the inquiry and in said inquiry, the additional secretary to the government of Assam Agriculture Department has submitted his report on 2nd of June 2023, wherein it is stated that as per the contract awarded to the respondent number 8, the P seats have been supplied to the corporation and the same has also been distributed to the agriculturists. It is also stated in the inquiry report that the agriculturists have sown the crops and has not made any complaint regarding the quality of the seeds, P seeds supplied by the respondent number 8. Full stop. The inquiry report further states that the complaint of the petitioner was taken seriously and the matter is referred to the CID for investigation. Full stop. As per the concept for the respondent agriculture department, the said inquiry is still going on.
That's it.
That inquiry by the CID is going on.
Yes.
As per the council, for the home department, you are for the home department. Home department, the inquiry is, the inquiry by the CID. The investigation by the CID is still going on. Stop. Taking into consideration the above facts and circumstances of the case, we are of the opinion that the purpose of filing this present PIL is justified, and therefore no further order is required to be passed in this petition. However, we make it clear that by passing this order, we are not exonerating any erring person. We are not exonerating anybody, and it is expected that the CID shall investigate into the matter in a fair manner and thereafter furnish a report and thereafter conclude the same without being influenced by any order passed by this court in this PIL petition. With these observations, this PIL petition is disposed of.
Obliged.
Item 27.
So the reply.
May I please understand? My lord, the petitioner's, my lord, ME school was amalgamated with, my lord, another nearby higher secondary school, my lord. With his original, my lord, scale of headmaster in the ME school, my lord. Though he is by order and law, my lord, allowed to work in the, my lord, higher post, my lord.
You have challenged this 28(3).
Yes, my lord. Now, my lord, he is told, my lord, department, my lord, is doing something, my lord, positive, my lord, to cover up this gray area, my lord. So at this stage, my lord, he will, my lord, praying to withdraw this petition with liberty to file, my lord, in future.
This petition with liberty to file if occasion so arises.
My lord. Deep level.
Item 28.
My lord, in the last occasion, on 29(3), my lord, 29(4), the customer was directed to file the application.
About 2 weeks time to file counter affidavit. Yes.
Lordship, in fact, I have received the affidavit, but some defect has come up. Lordship, give me 1 week's time.
Okay, Mr. R.K.D. Chaudhary, Monday Deputy Solicitor General prays for some more time to file counter affidavit. Time rate for the answer is up to 2 weeks.
Possibly.
Item 41 to 44.
Lord, it's a series of writ appeals, my lord. We sincerely pray, my lord, that that may be taken up for disposal in a hearing day, my lord.
It is only for disposal today itself.
My lord, actually, we are of the understanding that the state was supposed to file a counter. And we thought that they will file it. Now they have said that they will not. So, my
Go
lord,
on with this understanding and let the matter be decided. You decide yourself why you approach this court. If you are so, your understanding is so, I mean to say that it up to this level, then get the matter, resolve yourself.
no, my lord,
If lordship takes it up and some other day, my lord, if they file, they do not file, that is their choice, but at least, lord. Any other thing for you?
Are you required to, you are desirous to file any counter to this or what?
No, my lord.
No. Learned concept of the respondent state has submitted that there is no requirement of filing any counter affidavit to this writ appeal. Stop. Parties have submitted the matter may be listed for admission on any other day. When?
Anything on your lordship.
It's on so and so. Matters may be listed. 2 weeks. 2 weeks.
My lord, I pray for a liberty, my lord, to file an additional affidavit because of the fact that.
We have not passed any order. We have recorded this, that they are not in requirement of filing any counter affidavit.
Item 45.
May it please your lordship. Lordship, in this case, I have challenged the single judge order dated lordship, which have been impugned in this writ appeal lordship 7/11/2023, page 142. In this case, lordship, the previous 142 lordship. And relevant portion is lordship 146, paragraph 10 onwards.
Just.
Ms. Chaudhary, what is wrong with the single judge's judgment?
Lordship, our case is that, Lordship, though the civil court judgment was not challenged by the appellant's Lordship. Lordship, at that relevant point of time, there was a notification which says, as per civil court's direction, revenue records may not be corrected, Lordship. We objected, Lordship, before the revenue authority. And thereafter, Lordship, that was taken into consideration, but after Lordship hearing and all this, Lordship, the records were corrected, a separate patta was issued in favor of the respondent number 1 to 4, Lordship, predecessor's name, Lordship.
As per the decree of the civil court.
Decree of the civil court. That was challenged by the Board of Assam Waqf Board, Lordship, but that was also dismissed, Lordship. We have not challenged that civil court's order, Lordship, but we have objected before the Deputy Collector, Lordship. So, Lordship, the separate patta was issued in their name, and challenging that, Lordship, we have filed revenue appeal. So Revenue Appellate Court, Lordship, held that civil court's order is not binding on them. And the creation of, Lordship, the separate patta is also illegal. So they directed that, Lordship,
Civil court is not binding, the degree of the civil court is not binding on the revenue board.
that was held by Revenue Board,
That
Lordship.
is absolutely
Lordship.
against the law.
That was negated by the learned single judge, Lordship. My case is that, Lordship, during the pendency of the writ petition, records were called for, and Lordship, in that case, Lordship, a stand was taken. We have taken a stand that, Lordship, as per notification in the year 1984-87, Lordship, there was a notification by the Revenue Authority that as per civil court's direction, records may not be corrected, Lordship. That notification we may be allowed to put, Lordship, submit before the writ court, Lordship, and they may.
So if that notification is there, they may say whatever it may be, tomorrow revenue department will say that the Supreme Court judgment is not law of the land. So
Lordship.
we'll assume it.
But, Lordship, our case is that, Lordship, that plot of land, the entire Muslim Qabristan is a Waqf property, Lordship. So within that Muslim Qabristan, that shrine is not a private property, Lordship.
That is the decree of the civil court that has been, that has not been challenged.
Lordship, that is correct.
Again,
That,
finality till date.
Lordship.
Assam Board of Revenue, Assam Land Revenue Regulation. It's regulation 116, right?
154C, Lordship, bar of civil.
No, not that. 116, which mandates that the revenue records will be corrected as per the decree of the competent civil court.
Lordship, that is there, Lordship. I am also admitting that as per civil court, Lordship, it is binding on the revenue courts also. There are so many decisions also, Lordship. But only the thing is that, Lordship, at that point of time, why it was deferred the revenue authorities from, Lordship, creating.
As per the government notification.
Lordship.
That can't be that, any notification against the law can't be taken.
Which is the provision in land revenue regulation which says the revenue records will have to be corrected as per the decree of the competent civil court. What's correction? Chaudhary, you are also not aware.
Lordship, records of preparation of records of right, Lordship, that were in that chapter. Now I'm not getting Lordship, but otherwise, Lordship, there are different citations also that says Lordship, civil court judgment is binding on Lordship Revenue Authority. That I agree, Lordship.
Then, and now you are saying the judgment of the civil court is binding on the
Lordship,
revenue
but
authorities,
Lordship,
but simply because the revenue department has issued a notification that those are not binding and therefore
Lordship, at that relevant point of time, Lordship.
whatever the relevant point of, whatever that
But
is the
Lordship-
settled law.
So we have not challenged that decree, Lordship. We directly filed our objection before the Deputy Commissioner, Lordship.
But ultimately, the the commissioner comes to a finding that since the entry was made on the basis of the
Civil court,
courts,
Lordship.
then it can't be.
Lordship. And
said to be
accordingly,
that.
settlement officer passed an order, Lordship, saying that Lordship, a separate fatta may be issued against that 2 kata 10 lessa of land, Lordship. So accordingly, we have challenged that before the Revenue Authority, Lordship, by filing an revenue appeal.
In this matter, your lordships, I have already communicated with the DC office Gwalpara, your lordship. My affidavit is ready. Has called for vetting, your lordship. I'll be filing shortly within 2 days, your lordship. The parawise comments which I have received, your lordship, it is stated that as the precept dated 8/5/1981 has lost its force after 3 years. Hence, order issued by the then additional Deputy Commissioner Gwalpara dated 22/6/1990 for correction of revenue record needs to be cancelled. Moreover, the Office of the District Commissioner Gwalpara will issue order for taking necessary steps to the Settlement Officer Gwalpara shortly after the status this.
Thursday, you find your affidavit by Thursday.
Thursday is probably, sorry, by Friday we'll have it next week. Tuesday.
File your affidavit by Monday. By Friday, I will take
Yes.
it on Monday.
Yes, your lordship.
Lordship.
Tuesday. Friday तक affidavit.
But so face some time to file affidavit on behalf of the
And this is on behalf of the additional Deputy Commissioner.
additional
Gwalpara.
deputy commissioner. She may so, Gwalpara, she may do so by Friday, by 24th of the May 2024. This matter on 28th of June.
Obliged.
28th May, sir. 28th May.
Obliged.
Obliged, your lordship.
Thank you.
And time may be granted to file counter reply.
You are for the
Respondent,
sole respondent.
sole respondent.
Became Mr. So and so. Depending on this, on behalf of the sole respondent, place for. Granted time to counter to the written petition, time to call is granted, please confirm.
Item 47.
Better pertain to victim compensation fund, my lord, we are hoping good news from respondent.
Good news.
Well, pursuant to the earlier order of this honorable court, both the finance department and the political department is set together. And the political department has placed a liability of some 27 odd crores, my lord. Out of the 9 crores have already been allotted. For the balance amount, they have been suggested to place a proposal to the finance department. This meeting was held on 14/5.
This 9 crore, we have already noticed in the earlier order
Yes.
sheet.
On 14/5, the meeting has been held. So they will submit a proposal, we will consider that, my
Learned counsel appearing for the, you are for?
I am for the finance department, my
Then counsel appearing for the finance department has submitted that. During the joint meeting of the finance and the law department officials,
lord.
it is agreed that the law department shall submit a proposal regarding the funds which are in requirement for the purpose of dispersing to the victims under Assam Victim Compensation Scheme 2012. They submitted that after submission of the requisition from the legal department, law department, the finance department will consider the same and will take effective steps for release of requisite funds to be dispersed to the victims under the victim compensation scheme. It prays 2 weeks' time to do the needful, just after 2 weeks.
Item 48.
May I pray for a date, my lord? If any date, my lord, suitable.
You ask the court.
Yes, my lord.
So in this case, I am hearing for the sole respondent, the petitioner, my lord. Now against the judgment of the single judge, we have also preferred an appeal, my lord,
You also preferred
an appeal, my lord.
both of them you are agreed with the.
Yes, my lord. There were the 3 charges, my lord. The learned single judge held that 1 and 2 is not true, but 3 has been, charge number 3 has been held to be proved. So against that, we filed this appeal.
Was
There's a delay,
charge
my
number
lord,
3 is,
my lord.
charge number 3 is.
Charge number 3 is, my lord, that I took a loan from HPCL, my lord, corporation, but I did not pay it back, my lord. In fact, they have, after reinstating me, they have recovered every month, money, my lord. In case of 5 lakhs, they have recovered 17 lakhs from me, my lord. So I say that on the face of it, this charge is not maintainable, my lord.
This fact was not before the learned single judge.
Well, yeah.
How the learned single judge dealt with it.
Learned single judge held that the money was not recovered. What happened, my lord, when I tendered my resignation, that time the loan was pending. So after the loan, the resignation was not accepted by HPCL. So the litigation was going on. I applied for VRF, that was also not given. Then I filed 2 writ petitions to allow me to join. The learned single judge, that case allowed, saying that the corporation has to take me back. Then they filed an appeal before the division bench. Division bench also said that join, otherwise there will be contempt. Went to Supreme Court rejected, my lord. Ultimately, that they have reinstated me 2009, placing me under suspension and held the DP. And while reinstating, my lord, they were deducting 2/3 of my salary. That way, they have deducted 17 lakhs from me in where the original loan was about 5 lakhs, my lord. So I say, my lord, on the
What was
face
the
of it,
number of that appeal?
my lord, appeal, my lord, there is a delay. So IA has been registered as 1238.
We can concept of the respondent number 4.
4, my lord.
Respondent number 4 is submitted that.
No, sole respondent, my lord, here.
Here, sole respondent.
Madam.
The concept of the respondent has submitted that the respondent number 4 has also preferred the appeal against the impugned judgment. Is
Your client has preferred an appeal.
Another appeal.
Who is the respondent number 4 in this appeal? You are,
He is Abhijit Kumar Borwal.
Abhijit Borwa, my lord.
Only respondent.
Only respondent.
When concept of the respondent is submitted, then the respondent is also preferred an appeal against the impugned judge. However, the said appeal is filed with the delay, and therefore an IA has also been preferred for condoning the delay. He prayed that this appeal be listed along with that IA.
Lordship, I have a talk with the client's lordship. They say that they did not receive the notice of this.
Wait, taking steps, my lord.
So if my friend gives me a copy, lordship, I will obtain instructions with regard to that.
My lord.
The copy of the IA number so and so.
1238 of 2024.
Be supplied to the counsel for the appellants. List this appeal along with the IA number so and so. After 2 weeks.
Item 49.
It will be possible matter.
In this matter, I am appearing for the respondent. College, private college authority.
You are for the respondent number?
3 million, 4. Oh, 3 million.
3. You have filed the counter?
Yes, ma'am. But I am informed by the council appearing for the appellant that the party has taken the brief from him and is appointing somebody else. I don't see anybody here. My lord.
Who is the counsel?
It was Mr. Sharma. JP Sharma.
None present on behalf of the.
No.
Appellant. None counsel. Respondent number 3 has submitted that on last occasion. The counsel appearing for the appellant, Mr. JP Sharma, has pleaded no instruction. However, no new advocate has been engaged by the appellant. Full stop. The this matter after 4 weeks. In the meantime, the registry may ascertain whether any new counsel is engaged by the appellant or not.
Passover meter, item 8.
I have made a telephone call to the advocate through my junior. He is in Bomdila.
He is in Bomdila. Adjourn, then we'll adjourn. Adjourn for 2 weeks, none present, adjourn for 2 weeks.
None present for the
Appellant. None present for the appellant, adjourn for 2 weeks. Yes.
Passover meter 24.
May I please as your lordships? Lord, the facts is regarding Milord holding the charge of an headmaster of a high school, Milord. Initially, Milord, there was no qualified person was there in the cadre of graduate teachers. Accordingly, Milord, I was allowed on the strength of my qualification as well as the B.Ed degree, which I my
Qualification, that B.Ed degree.
B.Ed degree is required, Milord, and which I had from a Milord university called CMJ University, Milord. And Milord, during the after 2 years of that holding the charge, Milord, and continuation in my service as in charge headmaster, suddenly the impugned order has come up, Milord, removing me and given the charge to my friend, Milord, the private respondent. As he has in the meantime has Milord got the B.Ed degree from Milord a recognized institution. Now in the impugn order, my lord, they have held that on the count that as the CMJ University is not recognized in the state of Assam. So, my lord, therefore, I am not eligible and qualified to hold the.
While referring to Rule 40,
My lord, Rule 14 of the 2018 rule, my lord, is the sub-rule 2 says that the B.Ed degree is mandatory and, my lord, required.
even for the in charge of.
In charge, my lord. In charge, my lord, what has happened in the meantime, however, the regular recruitment process has already been initiated, my lord, in the entire state and it is going on, my lord. It's going on and due to the model code of conduct, it is now on a hold, my lord. Till fourth.
How can you be continued?
Now, my lord, this dispute of that whether the CMJ University degree is, my lord, can be recognized or not. Only in the one count, my lord, the state has said that as the CMJ University has not been recognized by the National Council for the Teacher Education, my lord.
There's a decision, sir.
My lord, that decision pertaining to, my lord, Muktaram Deka's case, my lord, which has been referred by the learned single judge, my lord.
Yes.
It is, my lord, regarding those person, my lord, who obtain in the distance mode. What, my lord, I have obtained in a regular mode, my lord. That's why there is a distinction, my lord. And-
You just see,
My lord,
on consideration of all above particular days, decision of the apex court in national so and so,
my lord.
and the OM dated so and so, the government of Assam, and having noted that the imparting B.Ed degree by bachelor so and so, so and so, so and so, prior approval was not accorded by to impart teachers education. I am of the view that B.Ed degree awarded by these institutions not legally valid.
My lord.
This is what the Ram judgment says.
My lord, my lord. In that case, my lord, I was also a party, my lord, representing
But
the.
sir, here,
My-
there is no distinction from the distant or by education or any other.
But
This
my lord, in-
B.Ed degree by the CMJ University,
But my
that
lord,
has been declared to be unrecognized.
my lord, that distinction is there, my lord, that judgment, if my lordship may be pleased to peruse, I can produce that judgment, my lord. There is a
But
distinction.
ultimately, sir, your degree is valid, at least some document must be there or some.
Yes, my lord. But the document which we are relying on, my lord, that, my lord,
Yeah.
my lord, the document and the judgment of the Honorable Apex Court, my lord, which I am relying on, my lord, has the Honorable Apex Court as well as the Rajasthan High Court has held that, my lord, that once the UGC has recognized a university, that separate recognition from the NCTE is not required, my lord. My lord, that judgment, my lord, may be pleased to find. No, it's everything basically. I'll put China separately this. My lord, this is a judgment of 2008 3 SCC, my lord.
This apex court judgment, National Council for Teacher Education.
My lord.
Where is that?
No, my lord, here in the paragraph 18 and 19, my lord.
So that is, this the judgment, this NCET judgment is after this judgment, no?
No, my lord, it is prior to this, my lord. This is of 2008, my lord.
2008 and this NCET judgment of the Supreme Court is?
Supreme Court itself is 2008, my lord, that came up for a basic education board UP versus Upendra Rai and others, my lord, delivered on 12th of February 2008.
Muktaram Deka.
Muktaram Deka is after this, my lord, after this,
After this.
my lord.
And this in Muktaram Deka.
Muktaram Deka's judgment, my lord, this has not been considered, my lord.
But in this judgment,
My lord.
this is reference of this apex court judgment in National Council for Teachers Education was there.
Was there, but my lord, that was in a different context. My lord, may I pray that this matter can be taken up on Friday, my lord. I will try to satisfy as a last chance, my lord, if I can, my lord. That Muktaram Deka I will also place.
Welcome.
My lord.
At the request of next week, whatever the day.
My lord. My lord. Oblige.
Pass over meter 29.
May it please, your lordship. My lord, this is a writ appeal
Yes,
listed for admission hearing, my lord.
yes.
The writ appeal,
For the government, my lord. Here, copy of the writ appeal memo has not been served to us. Only the
Not
delay
been served?
condemnation, yes, madam. I checked the record.
You are in receipt of what?
Only of the, my lord, that IA, my lord, relating to condemnation of delay, my lord. That was served upon us. Thereafter, my lord, the appeal memo has not been served. In the
Mr.
last
Consul,
occasion, I
you have
requested,
to-
madam.
this fact you should have mentioned in the earlier also in the morning itself.
My lord,
When the
I
matter was taken
yes, no,
up.
I checked the record, my lord, in the breakout.
anyway, my lord, the other writ appeals arising out of the same impugn order have been admitted and taken for final hearing. I think the batch of writ appeals is listed tomorrow before your lordships, my lord.
Yes, my lord.
So in the meantime, you supply the copy of
My lord,
the,
certainly.
okay, look here. It is submitted by the council for the parties that similar appeals are listed tomorrow. List this matter tomorrow. In the meantime, the copy of the appeal be served to the council for the respondent during the course of the day. Tomorrow.
I'm grateful, my lord. I will do that. Great.
Pass over meter 30.
Yes.
My lord, so impugn order is page 84, my lord. My lord, learned Central Administrative Tribunal, my lord, dismiss my original OA, my lord. And the reason is that, my lord,
Para number 4.
yes, my lord. But my case is that, my lord, before, my lord, the passing of that order, my lord, there is no show cause notice about my allegation which was leveled against me, my lord.
That they will do, they simply transferred you from one section to another section.
That is correct, my lord, but
So why you insisting on to
no,
remain on
my lord,
the
post, now, my lord, I have given the post of gangman,
given the post of
gangman, man, in gang number 27, lordship.
gang trolley man?
No, no, my lord. Lordship, may kindly see page 23 is the original impugn order, my lord.
23.
Yes, my lord. That's why, my lord, the works are different, my lord. I was, my lord, forced to work, my lord.
23.
Yes, lordship.
Read.
My lord, the office order, the following transfer and posting order is issued to take immediate effect. Height so and so, dated so and so.
Trolley man P1 itna
Yes, ma'am.
under
It has been
SSC is
founded,
transferred and posted to trolley man under SSC,
yes.
except in bottom seniority of mutual.
No, my lord, page 23, last.
Page
23, my lord.
3, yes.
This was the order which was,
SSC forwarding so and so, it has been found that there was track maintainer.
yes, my lord.
Third, trolley man, in bracket it is mentioned a trolley man under SS did not follow the instructions. Negligence of duty, also negligence, landscaping and the other transfer the post of gang number 27 as track maintainer 3.
Yes, ma'am.
So you were
I
earlier
was-
also working as track maintainer and again.
No,
you have-
I was, my lord, the trolley man, as a trolley man, my lord.
Here they have mentioned track man, so third in
Track
bracket
maintainer.
trolley man, in bracket trolley man.
Yes, my lord. Now, those poster, my lord, they categorized as the same category, my lord. But the post, my lord, gangman is different, my lord, of the trolley man, my lord.
Gang
And-
number 27.
Yes, my lord.
So how it is different?
That is different, my lord. Lordship may kindly
What's
see.
the difference?
My lord, the trolley man's works are different and the gangman,
What is the work of the trolley man?
my lord, trolley man, my lord, one trolley, my lord, it was run, my lord, and regarding that,
What?
my lord,
Track maintaining,
yes, my lord.
okay?
But regarding the gangman, my lord, as per my
Sir,
instruction,
here no such mention, keeping in view of the hereby transferred and posted in gang number 27 as track maintainer.
yes, my lord. Now he is, Lordship may, one letter, Lordship may kindly see, Lordship will find there, page 27, my lord.
27.
Yes, my lord.
Yes,
These are the allegations and the allegation, my lord.
so
It is
that
also
allegation,
stated,
forget the allegation.
no,
Just forget the allegation. Allegation is that you have not listened
my
to
lord,
the.
it is directed, so he has to transfer there, my lord. Because of that, my lord, this allegation, he was as a punishment, my lord, transferred that place. my lord.
Can't be a punishment in the same station, same place,
But my lord, the work is different, my lord.
Same place.
same pay scale.
Same
everything is
place at the
same.
Jomna, my lord,
There's
but
no
this
change
get,
in condition of service.
my lord. But it was not transferred in administrative purpose, my lord. Had it been, my
That's
lord,
why that is
administrative
also
purpose.
administrative purpose. If you are not listening to the seniors, they're
Yes.
supposed to transfer you. You are not listening to the
Ask
seniors.
them to draw DP against it. If that is what he wants.
You mean to say that they should have instituted an inquiry against you.
Yes,
For
yes, my lord.
punishment.
I am ready to face the inquiry, my lord.
That they will do.
My lord.
That they will do.
But
We'll make it clear that transfer him and if required so, initiate inquiry against
okay.
him. We'll do
But
that.
as per my lord, inspection, my lord, some interrogation was took place orally, my lord. And after that, he beg apology before the office, my lord. The other allegations so far, my lord, the absence of duty and other, my lord.
Mr. Consul, there
Lawsuit.
are many situations in employee has to be tackled in a particular manner and to
Lawsuit.
give a message to the other employees also that don't indulge in indiscipline, otherwise you will also be transferred. There are many things. There is
My
nothing
lord,
in
I
that.
have gone through a judgment, my lord. I have found that.
For this judgment,
Yes, my lord. Because, my lord, there is a punishment. Transfer order cannot be, my lord.
yeah, that's right.
That will, my lord, also, my lord, cast stigma in my service career.
Please don't stretch it to so far. We are not inclined to entertain.
My lord, may kindly fix on the next week, my lord, one senior,
Next
my lord, one senior, my lord, there you are here. My lord.
You are working on the very same station, not here and there only.
But my lord,
You are asked to work in that room, that's all.
But the works are, my lord, different, my lord. His body not support that work, my lord.
That's why only you want to know what's the difference between both the works.
Yes, my lord. So
There
next
is
week,
some extra, some material is there in that earlier post.
yes, my lord. Trolleyman, my lord, just, my lord, this is not so hard
So
work.
he's getting some extra benefits.
No experiment, but
No,
works are totally different, man. My lord, this gangman position is the original position of him. And this trolleyman is a promotional post, my lord.
Now you have been posted to a promotional post.
No, my lord.
So
In
how
gang,
it is promotional post, the same pay scale is there.
my lord, last one thing, my lord, in the impin order, it is stated track maintainer, my lord, the 3. And in their affidavit filed before the, my lord, the central administrative tribunal, they stated track maintainer 2, my lord.
Just 1 minute.
Last.
ये उसमें जाएगा ये punitive
Yes, anything else?
My lord, one letter, page 78, my lord.
Yes. 70.
My lord, I am allowed to read my lord, last 2 paragraphs, my lord.
Yeah.
After repeatedly warning him, he is not performing his duty, which has grown to extreme level beyond my tolerance level. In addition this, he always disturbed me by asking sick memo, but being absentee, sick memo may not provided, but he behaved with argument manner with slang language. Moreover, he has asked program as trolleyman. But I each and every time advise him that you are being sprayed to gang number 27 and you have to perform duty to the gang, not as a trolleyman.
This is what, this is a letter by you.
My lord, this letter was written to the higher authorities, my lord. That copy also not supplied to me. But meaning is thereby, my lord, that post and that this gangman is not same, my lord.
Same, nothing, English.
My lord, kindly next week, my lord.
The next week, see, what do we mean by next week?
My lord, I will explain the
This
difference.
combination is very much there here in the next week also.
My lord, no, my lord, I want to argue before your lordship, my lord, but only, my lord, I show the difference, my lord, what the difference between two.
Exactly.
Oh, my lord.
For hearing, item 51 to 54.
My lord, pursuant to last order that is 25/8/23, they have passed an order
25,
8/23, my lord.
yeah, during the course of submission.
Yes. May I read it, my lord?
On court attention to communication. Yes.
Pursuant to this order, my lord, they have passed an order whereby our claim has been rejected.
Your claim has been rejected.
Rejected.
Yes.
There are two ways, my lord. Either we will bring that on record by a small affidavit, maybe in a day or two.
Since if your claim is rejected, then there is a fresh action, you may file.
That is also there, my lord. But my lord, having regard to the peculiar facts and circumstances, I will respectfully pray, my lord, 2 or 3 days, I'll just file it if they got the copy. Bring it on record. And also may like to consider that our only case is, my lord, this particular work has been now performed by somebody else. The only thing is my security is involved, my lord.
Okay.
Only one point is, my lord, there was no contract between us and the FCI. Right? EMD, yeah. Initial security, we call EMDS. So about 1 crore rupees, more or less, my lord, is involved.
So
now the work has been performed. Supposing if your lordship allows the appeal, all that will happen is they will not be able to forfeit my honest money. That is the only point.
Otherwise, how they are going to forfeit your money?
My lord, now they cannot, in our humble submission, for the simple reason, there was no contract entered into also. So they cannot invoke the contractual clause also.
No, if the contract was not there, then why you have not?
As a default. They are treating them as default.
Defaulter. But since there is there was no contract in between you and these people, then why you have deposited the money? Or
no, initially, my lord, we submitted tender. What had happened, my lord? We were carrying about 22 tons of food grains.
Fine.
From railway go down to, my lord, Baraksali, we are carrying the food stuff.
FCI.
And my lord, that Supreme Court judgment came whereby it was brought down to 10 MT.
Yeah.
Now they themselves wrote to the Assam government, please relax it. So therefore, when the offer was given to us, we said we can't perform because of the Supreme Court order which has started, enforcing. That is the point, man. It's a peculiar man.
So learned single judge has held what?
The learned single judge has decided against us. So 2-3 days time may be given, we'll bring out on record that order, man.
Tuesday.
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 No, can it be on Thursday? Can it be on Thursday?
Thursday.
No.
Thursday.
Thursday की तारीख भी 0.
30th.
Please study.
Development.
Item 56.
May I please say this matter may be taken some of the notes
Adjourn.
on Monday or Tuesday. Lord.
Adjourn.
Item 57.
Amit recall has.
May I please, your lordship, lordship, this appeal is against an order passed by the learned single judge, the Isol bench in WPC 17 of 2016. This matter relates to lordship rental compensation. And the operative portion of the order, if I may take your lordship to page 51.
Yeah. The assessment.
Yes, I'm just reading out, lordship, paragraph 6 onwards. The assessment of rental charges for occupation of the land of the petitioner by the armed forces was assessed by the respondent number 6 for 3 periods with effect from 1966 to 1986, January 87 to August 2008, and September 2008 to June 2011. Insofar as the assessment of the first and the last period is concerned, the same are already satisfied by the Ministry of Home and the state government respectively. For the second period of occupation under the Ministry of Defense, the amount was assessed as 47,50,350. It is for this period that the petitioners have made their claim along with interest for delayed payment. It is the contention of the respondent number 1 and 2 that they have paid rental compensation for the area covered by the blueprint sketch map covering an area of 6.991 acres. However, the joint verification conducted on 15/11/2011 came to the finding that the land of the petitioners actually fell within the area covered by the blueprint sketch map. And if such is the case, it appears that the joint verification or the board proceedings of 1992 to 1993 appears to have excluded the land of the petitioner by considering their land to be government free land. And accordingly, lordship, the last paragraph.
Since it is found that the land of the petitioner are within blueprint area.
Yes.
So the spot verification
Yes.
was conducted. The minister
Was
would only.
the Ministry of Defense would
liable to
only
pay
be
the
liable to pay
As was.
as
assessed
was-
by the respondent
as a-
communicated to the
yes.
state government and the revenue.
in the revenue department. So, and therefore, lordship, we were directed to pay the compensation. So my submission before your lordship is, lordship has noted in the previous paragraph that the blueprint sketch map area covering an area of 6.991 acres.
Yes.
Now, this is the area where out of a total area, this is the area which are private lands, which we have taken.
Required for the,
Yes.
used for the.
Yes.
Army purpose.
Yes, this is a small area out of a big portion, which are private lands, which have been taken over by us, for which we are bound to pay rental compensation. My case before your lordship is, for we are not paying rental compensation individual wise. We are paying it for the area, 6 point that. And that amount we have already released to the state government. We do not pay it individually. So it has to go through the state government. We have made that payment, Lordship. Now, that is also reflected in the judgment at page 47. Now, the case of the petitioners before the single judge is that since they reside within that that area, they are entitled to rental compensation. We do not deny that, Lordship. If they are within that area, they should get, but we do not pay it individually. We have already given it to the state government.
You have assessed that this much of land was used for the army operations.
No,
Therefore,
not operation, Lordship.
operation in the sense for army use.
Yes, Lordship.
And for that, you assess that amount and deposited it with the state government. Now it is the liability of the state government. To
Yes,
disperse that money to.
ABC, whoever is there, they have to get it, Lordship. So that is our case, Lordship.
So the learned single judge, what the learned single judge is ordered for?
That since they are within that area.
That in your repetition disposed of it there. Arrange the fund of payment of rupees compensation to the tune of rupees 200 along with the interest on the date of assessment up to date of filing of the present disclosure. The amount should be deposited by the respondent before the respondent within a period of 8 weeks. But as per the appellants, they have already deposited.
We have
this amount.
deposited it with the state government, Lordship.
So then why you are worrying about that?
So there is a direction against us, Lordship.
Against us?
Respond number 1 and 2.
Who is for the state government? So once they have paid the money, then you disperse it to the. 12. Yeah.
We have filed additional affidavit, Lordship.
Azarical on next date, the state government revenue shall apply the quota into how on what basis. And who has qualified the amount of such information shall be furnished by the competent authority.
We have filed details affidavit, Lordship, on 30 May 2023, Lordship. That is on at page, Lordship, 418, Lordship.
Yes, additional affidavit dated.
Lordship, that is 30 May 2023, starts from page 418, Lordship.
Yes.
Lordship, here 3 parts, Lordship, kindly say page 421, Lordship, paragraph 6.
Yes.
By applying the aforesaid method, formulate calculation, the rental compensation payable to the respondent for the period of 1966 to December 1986 was assessed at rupees so and the same was already been paid to the respondent by the Ministry of Home Affairs. A table showing the assessment of rental compensation already paid by the Ministry of Home Affairs of the for the period of April so the method so that is a total occupied by the respondent. That is one part, Lordship, 1966 to 1986. That was already paid to the read petitioner, Lordship.
1966 to of 20 years around.
That was already paid, Lordship. Then, Lordship, paragraph 7, Lordship, that is important. That is the direction of the single judge, Lordship, to pay.
Yeah.
The respondent herein are also entitled to monthly rents from January 1987 to August 2008. As per the aforesaid method calculation, the amount payable for the said period from January 1987 to August 2008 is rupees 47,50,350, and the said amount is due and payable by the India Defence Ministry. A table showing the assessment of rental compensation payable so-and-so period, the method so-and-so are reproduced with Lordship. So that is the due, Lordship. That is my stand, Lordship.
So your case is, they are saying they have already paid and you are saying no, they are not.
No, that was the affidavit, Lordship.
Yeah, paid for one part, but not the other.
There are 3 parts, Lordship.
66 to 86.
Lordship, kindly see paragraph, page 44 of the main appeal, Lordship. Lordship, page 44 of the appeal, Lordship, everything will clear. Interpol. Mohit Karan.
You satisfy us that you made the payment of this amount to the state government?
Lordship, can I just come in?
Yeah.
Actually, they themselves say they have not paid. Please come to page 54 of the writ appeal. Yes. Actually, my lord, there are three periods. April 1966
To
to 31, 866.
31st of 1986.
Yes. The
January
second period
19
is January 87 to August 2008.
And third is September.
Third is till date of dehiring, that is June 11.
Yeah,
First and third period paid.
they have satisfied,
Ah.
yes.
Second, they themselves say they have not paid. Please come to page 54. Their affidavit before the learned single judge. Para 4, the sub para. Further, yes, it is submitted that the entire area measuring 6.99 acre at so-and-so has been dehired on 9/9/2008, and the Ministry of Defense is responsible payment of rent from 1st of September 86 to 9/9/2008 only. Liability, if any, before September 86 has to be discharged by Ministry of Home Affairs. Now, this is important. So far as Ministry of Defense is concerned, the rent for the entire private land in occupation at Bangwang has already been paid to the state government of Mizoram, except for the period 1/1/2008 to 9/9/2008, till the period of dehiring. Actually, my lord, they were under the impression that it is a government land. It is only when that blue sketch map was drawn and that inquiry was conducted, then it came to the notice that no, this land belongs to this petitioner.
And
So this is the case, my lord. Lordship, read the next paragraph also.
yeah, okay. Read.
Now, the statements made in paragraph 3 of the writ petition are denied. However, the answering respondents submit that the petitioners are put the strict proof of the alleged pass allotted by the erstwhile chief of Chaltang named Sailala in the year 1949. Pass number 1/1970, right, so and so dated 29/4/1970, and house pass number so and so. 143 of 2004, 145 2004, 146 of 2004, and 148 of 2004. In the meantime, the Sri Ronu, the then president so and so village, has no right to issue a duplicate pass 1 of 1970 white memo so and so dated 29/4 to 1970. Now, this period, Lordship will see, the area was under our occupation. We were there from 66.
And show us what you have said earlier, that we have already paid this amount, 6.99 acres, which is the land belonging to the private respondents. Yes, army has used it, but so far as regarding rental is concerned, you have already referred it or made payment to the state government, and now the state government is required to disperse to them, to the eligible persons. This is what your argument is.
Lordship.
Now you are altogether saying this is not their land and we are in occupation of 1966. How this matter?
A small clarification, Lordship. Initially, it was under the MHA.
Yeah.
Under the MHA. Then later on, it came under the army. After the army has come into possession, Lordship, there is no default on the part of the army. There is no default in payment of rent.
so far as the defense is concerned, Ministry of Defense is concerned, Lordship. Since it was prior, it was under the Ministry of Home Affairs. And it was transferred to the Ministry of Defense. I need a very short time to get a clarification from the Ministry of Home Affairs. This appeal is filed by the Ministry of Defense. I need a small. If
Make the payment, the respondents are not concerned.
that
He
is-
make payment, you
No.
make the payment to the state government or the state government make you pay the compensation to these persons, that's all.
No, that is what, Lordship. Since the defense forces have taken over the land, there has been no default. If there has been any default in the payment of rent, it was when.
So you mean to say that this land was earlier in occupation of the MHA?
Yes.
And later on it came in your occupation?
Yes, Lordship.
So therefore, for that period, MHA will pay. Then why you are agreeing?
Lordship. That's,
So MHA, what is this?
I need a very
Government
small
must
time to
be
get a
speaking.
clarification from the MHA on this. Lordship.
Get your clarification.
Because as rightly followed from your Lordship, after all, it's the government of India. My learned friend represents. But
That department.
yes, Lordship, I can understand that.
Well,
After 10 days, Lordship.
After 4th June or not, tell us that. You want it after
That
4th
would be
June or
fine.
before 4th June?
That would be fine, Lordship. There's a cephalogist called Pradeep Gupta. Pradeep is a very renowned cephalogist, my lord.
Okay.
The other day, 3 of them were there. Somebody says this would be the result, the other said this would be the result. Pradeep Gupta says, खेल अभी बाकी है.